So welcome to the September 27th, 2022 Zoning Board of Appeals meeting of the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do a roll call. I will start with myself, David Murch.
Greg Dean.
Fred Muller.
Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes from August 30, 2022. Old business. Deliberations on the following matter tabled on September 26, 2022 special meeting. Administrative appeal, re-notice of violation issued 1/28/2022. Applicant Leah B. Rachin, location 28 Whitetail Lane. Follow that by a public hearing on following matters tabled on September 26, 2022. Administrative appeal, re-notice of violation issued 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine LLC, Robert Durant, member and manager, location 28 Whitetail Lane. Following that, new business table on September 26, 2022, administrative appeal, re-denied business license, applicant Adam Nappy / Highwire Hydroponics. Then finally, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, address, and affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So first up on our agenda is approval of minutes of August 30, 2022. Does anybody on the board have any questions with regards to those? Any corrections to be made before we make a motion to approve? Okay, motion to approve the minutes of August 30, 2022 as submitted. All those in, oh, thank you. Yep. All those in favor, David Murch, yes.
Fred Muller, yes.
Greg Dean, yes.
Pete Lockwood, yes.
Okay, that will be unanimous. Old business, deliberations on the following matter tabled on September 26, 2022 special meeting. We have two administrative appeals as for 28 Whitetail Lane. These are on the table. I'd like to get motions to take them off of the table. Can I get that motion?
So moved.
And can I get a second?
I'll second that.
Okay, all those in favor of taking these two administrative appeals tabled for 28 Whitetail Lane off the table, in favor, David Murch, yes.
Fred Muller, yes.
Pete Lockwood, yes.
Okay, those are off the table. So the first up is deliberations on the following matter tabled on September 26, 2022 special meeting. Administrative appeal, re-notice of violation issued 1/28/2022. Applicant Leah B. Rachin, Esquire, on behalf of Management Controls LLC, location 28 Whitetail Lane. lot map 001020, zone LRR2, description administrative appeal from notice of violation. So Attorney Wagner, can you sort of work us through our procedural steps here?
Sure. So as you will, can you all hear me? Yeah. So as you'll recall, the board closed the public hearing and then table deliberations. So I do see that Tom just joined us.
Yes, I do see that.
Yes, I'm online. I don't know. I tried 4 times to log in using Sandy's link, but it didn't work.
Okay. So since, although we've called the meeting in order, since we haven't begun any substantive discussion, I see no problem with Tom joining us for this, unless there are any objections by the other attorneys. Seeing none.
Obviously not here.
No objection from the town.
Okay.
It's
Thank you.
specific to his timeliness in participating tonight. No objections.
Okay. Understood. So we have 5 members participating. Before we go into deliberations, the board, or rather the chair, I believe, has received 3 different submissions in advance of tonight pertaining to this matter. 1 from Attorney Wyckoff and 2 from Attorney Braun, and they are both following up on questions that were asked by the board. I'd like to address those 3 items in turn, and some of them, but not all of them, and so we'll address it in turn. I think introduce what would be considered evidence, and the record is closed. So if you want to accept that evidence, you would need to make a motion to open the record back up, and then I would recommend motions to accept the evidence or not into the record, and I'll walk you through that. So, sorry, Attorney Rachel.
Thank you. Just a quick question procedurally. Are we going to have a brief opportunity, attorneys, to weigh in on that, just the procedural issues?
Yes.
Okay. Before the motions are made, whether or not to accept them?
Yes.
Okay, thank you so much.
So the first item I have here, bear with me while I just pull it up on my email. I believe the first one to come in was from Attorney Wyckoff at 10:36. Does everybody have a copy of this? Subject matter is administrative record content submitted by management controls. It's from an earlier chain. It's 10:34.
Yes. Yeah. Yep.
Yes.
Okay. I suppose what it makes sense if I can turn it over to Attorney Wyckoff just to explain what this is and whether, in your opinion, this is new evidence or just answering a question, and whether we would need to open up the record to accept that or not.
Sure, I'm happy to address that. Last night, Chairman Murch asked me to point to some documents that were referred to during the town's presentation regarding the width of the boat launch. And what I did was I sent an email in response pointing out where he could find those. So the document, the references were to a 249-page PDF that Attorney Rachel provided to the ZBA yesterday with a link, and that she shared a document. So the documents aren't new; they're already before the ZBA, and I'm just providing page numbers that the board can refer to relating to the boat launch. So I don't think it's necessary to move or open the record because it was already in the record.
Thank you. I'm opening up to Attorney Rachel and then Attorney Braun to weigh in on this if they want to.
Sure, just briefly, and I certainly agree that that document was part of the record, and I don't think a motion is necessary to entertain whether it should become part of the record. I did just want to make very brief comments about that reference. It's important to understand and appreciate the context in which that record from Mr. Morris was submitted. It was responding to the notice of violation itself. And we certainly appreciate that these are administrative proceedings and that the rules of evidence don't apply. But that said, it's pretty well established in law that there has to be some indicia or some indicators of reliability when it comes to that sort of the evidence that you're looking at. And so at this point here, there's no evidence that Mr. Morse had personal knowledge of the dimensions or where those figures actually came from. And so I think it's important to appreciate that you can't look at that from a legal perspective as some kind of admission from a party opponent. And especially because Mr. Morse is not a party to these proceedings. He's an independent contractor. And again, we don't know the basis of what those measurements were. So I will leave it at that. And we don't object to, that it's not the entry of additional evidence into the record.
Attorney Braun.
I would just concur with Attorney Rachen's comments, and would agree generally that it is already part of the record.
Okay, thank you. So my advice to the board is that I agree with everyone here that this is not introducing any new evidence. So I think you can take note of it and we don't need to make a motion to do so. But if the board feels differently, let me know. So hearing nothing, the board can accept this as something to consider in its deliberations. It's basically analogous to as if Eric had, Attorney Wyckoff had provided this answer during deliberations. And you can take the comments that the other attorneys have made under consideration as well when considering the relevancy and credibility of those documents. So the next item, I believe, came from Attorney Braun, and so this is an email that was sent to some of the parties. I guess one of the town's attorney was inadvertently dropped off on that email, but subsequently received it. So I'll refer to the original email being from Greg Braun at 12:11 p.m. and it includes an attachment of Bateau emails regarding tree removal. So Attorney Braun, I would turn it to you to just briefly describe what you're trying to introduce here and your arguments as to why the board should reopen the public hearing to accept that.
Sure. First, an apology. I'm noticing a lag in in volume here. So if you lose me, please let me know. Maybe it'll also inspire me to be a little less long-winded tonight. Regardless, at the end of requested or asked if I had any evidence related to the tree removal and who performed those services. At the time, I indicated that I did not have that evidence. After deliberation with my clients early this morning, we were able to identify several communications on point, and it ended 3 emails that specifically indicate the tree work that was performed on the 2 subject properties. The one that we've already come to resolution on, that being Fernwood, and this appeal being Whitetail. I would note that as it relates to this specific violation, the board may or may not deem it relevant in that it doesn't speak to whether or not the actions took place, but rather grants culpability or responsibility for those. Those questions seem relevant and appropriate to the next hearing that we have scheduled tonight, for which the evidence has not been closed. And so I would just acknowledge that as it relates to those emails.
Okay, Attorney Wyckoff.
So the town does object to it. I mean, the record was closed. Let me step back. First, as Attorney Braun stated, he was asked whether he had anything evidence relating to whether Q team had removed trees from the Whitetail property. He answered no. So then he produced these, he's provided these documents today and wants to have them included in the record. I mean, his client was on the text. So in other words, there was access to them, and there must have been a strategic decision to not provide them and to instead wait and provide them later. So I object to that. And then I guess beyond that, the documents, I'm not sure they have any value here. And they just confuse matters and make it very unclear. The messages don't refer to a particular property. It doesn't say what property the work's occurring on. So they're really not of any utility. So I wouldn't confuse matters, and I think they ought to be excluded.
Thank you.
And I want to be clear that right now, we're only discussing and determining its inclusion in this current proceeding and hearing, and not the one that is to follow related to Big Lake Marine.
That's correct. Attorney Rachel? Any comment?
Yes, thank you. As you know, I also represent Q Team, but because this appeal doesn't relate to Q Team, I'm not going to be making any submissions in that regard. So thank you.
Thank you. So members of the board, the question for you is, we'll just, I don't think we have to do two separate motions, one to open up the record and the second to admit. So we'll just call it I would suggest someone make a motion to admit the email and the second, and then that'll frame it up for discussion. And I can advise you on, the factors you can consider, or my opinion. So why don't we just queue up a motion?
Can't hear you, Dave.
I'll make a motion to admit or submit. Can you hear that?
Seconded.
Okay.
So the issue here is whether this additional document should be submitted after the record has been closed. As you know, there are no rules of evidence that apply here in terms of your ordinance. Obviously, once the record is closed, no documents, further evidence can be introduced unless the board decides to open it up to allow that evidence in. And it's my opinion that's within your discretion to do. In terms of guidance for this decision, I think Attorney Wyckoff's arguments touch on the two principles that are at issue here, which are one, fairness. Is this information that could have been provided before last night's hearing? Is there any legitimate reason why it wasn't? And I think you can factor that in. And the second principle is relevance. And, is this information something that, would help you make your decision, and you believe it's so relevant that it is worth allowing into the record?
Sure. I mean, I'll start. I appreciate the information that was provided. I do think that in terms of relevance to what we have to discuss next, it probably doesn't have any, but I would like to reconsider this when we look at our next appeal. Anybody else on the board?
I agree with you, Dave.
Yeah, I'm on the same page here. I think that there's definitely an issue of, it's a pretty, it's not an obscure question that was asked, and this is surprising that there's, evidence of denial of his client denies the violations is now introduced, kind of after the fact. I think it's a little unfair. Seems reasonable that should have been introduced with the rest of the evidence.
And I think we should, we need to relook at this with our next appeal.
Yep.
Okay. So I think we can just go ahead with a vote on this. So the motion was to approve this, or to bring this into the record, or I guess to open and then bring it in. All those in favor? All those opposed, David Murch, yes, opposed.
Lockwood, yes.
Fred Miller,
I'm
yes.
gonna, yes.
So that one is not going to come in.
Okay. So the next item is an email from Attorney Braun at 2:29. It includes 2 attachments pertaining to the accuracy of iPhone measurements and horizontal position accuracy of Google Earth. So again, I would turn it over to Attorney Braun to give a sort of offer of proof, if you will, as to what this is and your argument for why the record should be open to allow it in.
Sure. So again, similar to the last issue, this was a question that was raised at the end of the meeting. I at that time had no information. You'll recall, or you probably came to know, that yesterday was the first time I think any of us that were parties to this proceeding learned of the specific tools and methodology by which measurements and fact finding was conducted on the subject property. So this is not something that I had previously had noticed that was an issue or was relevant in the matters before the board. Following that hearing, I did online research today, and I was able to identify 2 articles that were clearly on point to the questions raised by the chairman. The first was an online article published in August of this year in a online technology journal and or magazine related to the iPhone, and specifically the iPhone app that the CEO testified he used on site to make these measurements and to establish whether or not a violation had taken place. This is relevant, timely, and it comes from, by all appearances, an honest and trustworthy source. The second is an article that has to do with Google Earth and the accuracy of its horizontal and geographical indica or measurements. This was published in a medical journal of technology. Again, something that seems to be clearly relevant to the questions at hand and comes from a noteworthy and trustworthy source. So again, given the lack of notice as it related to these being relevant issues in the hearing, given how spot on they are to the questions and concerns that the board raised yesterday, and given the source of the information, I do believe that the record should be reopened, and that these documents and the contents therein should be allowed to be discussed and considered by this board as part of this hearing.
Sorry, Attorney Wyckoff.
Thank you. The town opposes the opening of the record in order to introduce these 2. I hesitate to use the articles because I don't even know what they really are. The record was closed. The question was asked, do you have anything regarding accuracy of Google Earth or the Measure app? The answer was no. And then some time was spent and he identified these. So the problem is we don't know anything about these articles. We don't know anything. We don't know who the authors are. We don't know what the qualifications of the authors are. We don't know if the authors are viewing the same thing that Alex used. This is kind of like a medical diagnosis by Google. It's like I Google my symptoms and I was like, I find out it's for cancer, so I have cancer. That's what it's like. It's medical diagnosis by Google. And with regards to the Measure app, I mean, the article says, measurements cannot be off by a few inches. And measurements can be off by between 2% and 20%, et cetera. And I don't really understand. There's no explanation as to what that is meant by that to understand what might be driving differences in those numbers. And with regards to the Google Earth piece, candidly, I don't understand what it is. I don't even know what it says. I don't see how it could be helpful because it's almost indecipherable as to what it's saying the issue is with it, if there is an issue, which I don't really understand. So for all those reasons, both of those ought to be excluded from the record. Now, if you're inclined, if the board is inclined to allow both of these to be put into the record, then the town requests that you reopen the record for the purpose of Alex Soroy being able to address why these articles, whatever they say, don't matter and why they shouldn't impact your decision. Thank you.
And I'm going to go to Attorney Rajan first if she has any comment.
Thank you so much. Again, I'll be brief. Not only do we not object to the addition of this to the record, we join in that request. We think that these materials are probative of the relevant issue about reliability of the iPhone measuring app and the Google Earth. I echo Greg's comments that much of the testimony, it came as a great surprise that when I say he, I mean Alex, the code officer, had used this iPhone app. That was the first time, at least in my understanding, that was raised. And so I think it does bear response. If the notice of violation had said we used X version of the iPhone app to measure on a certain date, then we could have a cogent discussion about the accuracy of the measurement. But with the absence of that info, like, what version of the app was used or what day or what protocols were used when he implemented the app, then, we being the appellant, or appellants, I should say, there are two of them whose rights are, at issue here, then we don't have any ability to replicate or test those measurements. And so, as Alex himself pointed out last night, it is indeed, it's without a doubt the appellant's burden to show that he erred in his determination, but it's important to appreciate that there is a fundamental threshold requirement that the CEO be able to explain his methodology in a manner that ensures the accuracy of his measurements. And without, like I said, the ability to replicate these measurements, unlike, say, a tape measure, again, it creates a due process issue. And so we do believe that it's important for this information to be considered. And on that point, I would ask specifically that in light of these issues and the reliability of the measurement has become quite important to these proceedings, that when you are doing your deliberations and when you're issuing your conclusions and findings in this case, we would ask that the findings and conclusions specifically address whether or not accuracy of the measuring devices is considered and germane to your findings. And so we would make that specific ask that be addressed by this board. Thank you.
Thank you. Sorry, I'm just making a quick note. Attorney Braun, do you have a brief rebuttal?
Very brief. Just first to say that both articles explicitly identify the authors. I believe the iPhone app has a short summary of who they are and what their background is at the end. Both articles also are replete with citations to other relevant information. The date on which they were obtained, which is today, is clearly indicated on the top, as is the internet address. And so any member here who would so choose to either vet those documents or confirm any of the contents or citations, it's quite frankly an internet click away. And as it relates to Attorney Wyckoff's argument that they can't be trusted or they're confusing or we don't really know if they apply here, I would say all of that speaks to the weight to be given to the articles and what sort of outcomes to be considered or come to by the board, but it doesn't speak to whether or not they should be allowed to be entered. Thank you.
Thank you. So I'll turn it over to the board. As before, I suggest a motion to reopen the record and admit the materials, and the second to prompt that for discussion. But let me just explain that if the board were to affirmatively pass that motion, I agree with Attorney Wyckoff that the town should be provided an opportunity to respond, and that would include putting on additional evidence. That's if you admit that. So can I have a motion on that?
So move.
And a second? Do we have a second on that motion?
Second.
Thank you. So before further discussion, same advice applies. Fairness and relevance should be your guide, and this is a discretionary call.
So can we, do we have the choice of admitting, do we have to admit both, or do we have a choice of admitting one over another?
You could, it's entirely up to you. You can admit one over the other. I would, if you did, I would hope that the board has a clear articulation as to why one should be admitted and the other shouldn't.
Sure. So in regards to the documentation that was provided, looking at the horizontal position accuracy of Google Earth's high resolution imagery archive, the document itself was published December of 2008. All the reference material is dated from years 2007 and older. Given how technology evolves so rapidly, so quickly, a document that's 14 years old, I think is a bit outdated in terms of what we're looking at here for tonight. In regards to the other documents, I don't have an issue with bringing that in and hearing how Alex would compare that to what he does as well. Although I would have to admit this is just one person's opinion, but it would be, from my perspective, nice to hear Alex's feedback in terms of how it compares to his own work. That's just my 2 cents.
David, I agree with both of those points. I do notice that the article was 2008 and the other one is much more current. So I would agree. I'd also like to hear Alex's testimony on the iPhone app.
Well, but real quick, I don't want to get too much into deliberating on this, but is it reasonable to ask what specifically you think this evidence, which there's a lot of measurements that have been talked about, and I'm assuming that the iPhone article is in reference to measuring whether or not there was thresholds met for moving soil, or how long the shorelines were, how long certain distances were. It doesn't seem like any of these are, even if you take the maximum error that the article is saying, and this is kind of, I think, a central point, is we're not close to a tolerance that would make the violation under a threshold. So I'm not sure it's super relevant, to be honest with you. We spent a lot of time talking about measurements. It's amazing that there's smoking gun new evidence when it seemed like it was a central thesis to the appeal. I just don't fully understand. Even if you took worst case scenario on these articles, it doesn't. If you could articulate which violations you think that would put us under a certain threshold on it, that would be helpful. And I'll open that as a question to either Attorney Ration or Braun.
Sure. And so I'll start there. I think it's relevant to, in fact, any of the notice of violation points that speak to the measurements. First, as it relates to 10 cubic yards, of soil moving, and that's in point to point notice of violation 1 and 2. Establishing length and width there is terribly important. And as the article related to the iPhone indicates, there can be a variance of up to 20%. Not only that, but it also explicitly discusses the necessity to calibrate your device and how different either geographic variables or locations, i.e. connectivity or location compared to cell towers, can have an impact on what those variations or measurements might be. And so I think it's not just, as it relates to, meeting minimums here, but it's a question of whether or not the tool itself is even a trustworthy measurement for any of these violations.
Yeah, just to follow up on that, that's a good point. I think that part of the testimony was that Alex did calibrate this with a tape measure. Also, part of his testimony indicated that, well, I mean, that's my understanding of what he said. I see a lot of people shaking their head no, but that's my time. Like that's what I have in my notes. So I think that, you know, there was calibration done. He also did testify that his assistant CEO followed up and he with different instrumentation. I don't see any of these measurements, including the 10 cubic feet that you mentioned, that if these measurements were off by 20%, that we're below threshold. I mean, I think he mentioned quantities in excess of hundreds of cubic feet.
Well, and Greg,
So I
I'm
just
sorry, I
want
don't mean to cut you.
I guess like I'm still strong with the relevance. Sorry.
Right. No, that's fine. Just a point. It's cubic yards, and not to belabor that, but I mean, you know, that's the difference of, you know, a threefold, right? And so the distinction between a cubic yard and a cubic foot is actually quite substantial, exponential.
Sorry, yeah, but the tolerance is not exponential. It's 20%, so it actually doesn't matter what the unit is. The article, as I understand it, is it's percentage based. So 20% of, I don't think it matters.
May I address those points briefly?
Sure.
Thank you. So I agree with Greg's comments. A couple of other things is that, you know, I think we talked about if you are reading it most generously and that well, let me back up just with respect to the notion that because it was the article was written a while ago, I think it was a 2008 article, that it should not be admitted. Again, I think that goes to weight, but importantly, they do raise issues that regardless of whether technology changes, the fundamental salient points are that, you know, things need to be calibrated. That doesn't change with technology. You need to know what version is being used. So I think while technology changes, I think it's critical to point out that the flaws and importance of methodology, that doesn't change over time. Those are points that are, you know, in essence, they don't change. And so I think, as you know, Greg had said, that it's not so much about admitting it, because I think it is proper to admit. You can ascribe whatever weight you think, but just because it's old doesn't mean that the concepts described in there are irrelevant or untimely. The other thing that is important, I think, with respect to, you know, that swing up to 20% possible inaccuracies, I think it's also really important to remember that some of the violations that we're talking about here is for activities on or below the normal high water mark. And that, I believe, where Alex, I don't have the image, but particularly with the boat launch, where he placed the normal high water mark, that's inches. I mean, that's, if you recall possibly, is that how much work was going on below the high water mark? That could be inches, and that 20% could be significant. And so I think it's important not to minimize that.
Which violation do you think it's important for specifically, as a follow up to that?
Sure. Let me find expansion of the shoreline.
4.
Thank you. Yep. And the boat launch. I mean, as I said, I'm going to echo Greg's comments that it's absolutely relevant to all of them, but specifically, particularly when we're talking about a small area, which is below the normal high water mark, which I think several of the violations reference, then I think it is even more important.
That's all I've got, David. I think you need to wiggle your mic cord there a little bit.
Does anybody else have any other questions? No. So the motion is to admit these, open the public record and admit these two pieces of information. All those in favor, David Murch, yes.
Greg Dean, no.
Hennessy, yes.
Miller, yes.
Lockwood, yes.
Okay, so that's 4-1 in favor of admitting sorry, that was on both, correct? The motion was on both of the documents. Did everybody understand that that's what they were voting on?
Can't hear you, Dave.
Yes.
Okay, so everybody understood it was both documents, okay. So the board has motioned to open the record to admit both documents. As I advised, if we're going to do that, I think we should provide the town an opportunity to, as they requested, put Alex back on to speak to this, and again, give the parties an opportunity to respond, not to repeat what was already discussed, but just any further response as to the relevancy of this evidence. And also further, we should open it up to the public briefly to comment on this as well.
So procedurally, does that go then to Attorney Wyckoff and Alex first?
No, we should start with the appellant, actually. So Attorney Rachin, I think, should be given the first opportunity.
Okay, so I'm sorry, just to catch up procedurally, I'm going to be asking Alex a couple of questions in that regard, if that's the vision.
I guess however you would want to handle this evidence, you know, if you want to call Alex, you can certainly do that. Perhaps town will have an objection to that, but I think it's.
Yeah, I think here, oh, Greg, I see Greg's hand. Is that?
Yeah, apologies, Attorney Wagner. I may have missed this point, but I just want to be clear. So the last motion and vote was to accept these two documents, but I understood the admission of any additional testimony or evidence from the CEO to be a separate matter. Or are we discussing whether or not to allow that? Or have we just established that he's going to be allowed to produce additional testimony and evidence?
So the motion was to open the record and introduce it. I agree that it's a separate question for the board. I don't think there needs to be a vote here unless you're objecting and sort of insist that the board make a affirmative vote to allow the introduction of testimony in response to this evidence.
I mean, I would defer to you and your advice to the board on whether to vote on it or not, but I would note I would simply abstain on an argument either way.
And from my perspective, I was asking more for procedural clarification as to, you know, I think the language, or at least the advice that you had given, Stephen, to the board was that if those articles are admitted, which sounds like they have been, that you give the town and Alex an opportunity to speak to it, and then the parties would respond. So, and I think that if I remember the order of operations is that Attorney Wyckoff had asked that he be given that opportunity. So it seems to me that that would be, again, I defer to your good judgment, but perhaps have Attorney Wyckoff ask those questions or whatever questions he believes to be relevant, and then Attorney Braun, and because it was his motion, and then perhaps me, or whatever order is appropriate.
Yeah, I think that that's a reasonable approach. I deferred to our typical order. As you're the appellant, you have the burden, so I wanted to give you that opportunity first. But if you're willing to turn it over to the town first, I do think that has more logical appeal to it. So why don't we do that?
Makes sense to me. I can have Alex appear and take his mute off. Okay, good enough.
Evening. Hello.
Alex.
Okay, so Alex, what I would like you to do is to help the board understand and explain to the board why these articles regarding Google Earth and the Eiffel Measure app, why they don't matter and why they shouldn't be concerned about them. Okay, so
Yeah.
maybe first, the way for us to approach this is, you know, so the the violations that involve some kind of measurement, I think those are, and you tell me if you disagree, I think those are the location of 100 feet from the normal high water line, the opening in the canopy of 250 square feet, and then the 25 by 50 grid to apply the point system, and then the 10 cubic yards, the earth moving or filling of 10 cubic yards. Would you agree with me in that those are the items we need to be concerned about?
Yes, I would agree. Although I do think that some of those are a stretch when it comes to specifically the use of technology. But yeah, I'll agree for conversation's sake.
So let's talk about the 10 cubic yards first. Why doesn't any of this matter to the determination of whether 10 cubic yards were moved or earth filling occurred of 10 cubic yards or more?
And why doesn't the admission of the new evidence, that's specifically what you're looking for, right?
Exactly.
Actually, first, can I just ask a quick question on a show of hands? Did all the board members get a chance to read those two documents today?
Yes.
So everyone's up to speed. Okay, good. Yeah, so, I think when it comes to the calculation of the cubic yards of material, phone measurements weren't used for that. So I'm not sure why that's being discussed.
Okay. How did so just remind us why the board should feel comfortable that there were at least 10 cubic yards of earth moving or filling occurred?
Yeah, so I mean, first off, let's not ignore common sense here. I mean, looking at just a photo of the after result of this property, and keeping in mind 10 cubic yards is a dump truck, one dump truck.
Mr. Chairman, I just need to object to this line of questioning. This is just a reiteration of information. This has already been part of the record. I don't think we need to revisit testimony that was already given. This was very much the subject of the questioning prior to, and I don't think that this is appropriate to have somebody retestify as to the same things they've been already asked. This is about the accuracy of the measurements, not the measurements themselves.
And
May I respond? May I respond?
The question came to me, so I'll answer. I think I do think there's relevance to this. So if we're talking about accuracy, and if something comes down to inches, but we're really looking at it in terms of feet, yards, or greater, there's a big difference there. So I think from the board's perspective, it does not hurt us to get a recapture of that picture of what Alex's measurements were like, and his reasoning behind it.
Okay.
Thank you.
Yeah, so sorry, now I've kind of lost my train of thought there. So yeah, I think a lot of this we need to use common sense. Looking at this shoreline, keeping in mind that 10 cubic yards is a single dump truck of material. There's scientifically, mathematically, there's no way that there's less than 10 cubic yards of material brought in. But again, common sense. So the measurements of the riprap brought in, if you look at those numbers, let's say that it's 6 inches deep that was added on top of the existing riprap, 60 feet long, 10 feet high. That's already over 10 cubic yards. And those numbers are duplicated everywhere. And I don't see how you can argue that those aren't factual numbers at this point.
Okay, so then let's talk next about 100 feet from the normal high water line and why the board shouldn't be concerned as a result of these articles that have been entered into the record, why it shouldn't be concerned about that number.
So I think the accuracy number that I heard was 20% margin for error. So I think that puts us at, possibly us having it at 80 feet instead of 100. I think clearly all the work that was done, you need to go, please, go, has been done within, 20, 25 feet of the shoreline. If we are talking about work that was done, hey, can you come take him, please? Work that was done 75 feet and beyond from the shoreline, maybe we could have, a chat about accuracy. But as I read that article from a random blog post on the internet that anyone can post in 2022, it seems to be pretty favorable when it comes to iPhone measurement. And if we're saying 20% is the margin, then I think we have no issues at all, because clearly all the work was done much closer than 80 feet.
Okay. And by the way, what steps did you take to make sure that using the Measure app was sufficient for your purposes? How did you determine that it was?
Well, it's just one of the tools that's used. And, the Measure app, like I think I said last night, is, something that's been tested and is accurate to inches in certain situations, depending on, how fast you move, how light it is, and, making sure your camera is not covered with fingerprints. Little things like that can affect it. If it's used correctly, if you actually know what you're doing, it's going to be pretty accurate. Now, the other thing to keep in mind here, and the reason why I actually prefer to use that method instead of pulling a tape, is if you're by yourself, to take accurate measurements with a tape is practically impossible, because you have to then calculate what the slope is of your tape measure to take out the effect of it being a horizontal measurement. So these are things that we have to do to get these accurate numbers, and unfortunately that often involves using maybe technology that some people just aren't comfortable with or used to using. But we used 3 different types of measurement when it came to this.
Okay. And what do you mean by that? What 3 different types of measurement? What do you mean?
iPhone measurement, tape measure, and Google Earth.
Okay. So, and I think yesterday, I think you testified that you actually tested the Measure app on a tape.
Yeah.
And can you restate what the results of that test were?
Yeah, I mean, I could get it to be exact depending on, like I said before, all those variables. It is very sensitive to light. So if you're going to try to do it in, at sunset, it might not work as well, or after sunset. But if you have a light day and you're moving slowly, and you get a contrasting starting point and ending point, I can get it down to practically exact, maybe an inch or 2 off.
Okay. And you also mentioned that a tape measure was used. Could you describe what the circumstances there?
Yep. So actually, DEP came to meet with us on site last year, a whole year ago, when we did this, and they took a bunch of measurements that day, and with Chris Hansen, my assistant.
And they verified all the distances?
Yeah.
Okay. Now, next I want to ask you a question about the 250 square foot opening and canopy, and why the board shouldn't be concerned with regards to that dimensional number by these articles.
Mm-hmm. Yeah, so there's a couple of spots on the lot where they've opened up canopy in excess of 250 square feet. Why the board shouldn't be concerned? I mean, let's break this down. 250 square feet is only a 10 by 25 foot area. And if you look at, the before photos, the large tree that was over 100 feet tall that was taken on the peninsula, that had a width of, well over 10 feet, well over 25 feet. And same thing with the tree that was removed over near the stairs. Again, unfortunately, the ordinance was not followed. The contractor didn't meet with us on site prior to removing the trees. So we don't have an accurate measurement from end to end on how wide that tree was. We have to base it on the information we have. And that's not our choice. Unfortunately, that's what the town has to live with because the contractor didn't follow the rules.
But you know at least that canopy was more than 10 by 25.
It was definitely more than 10 by 25. And you know, there's measure tools other than Google Earth that we can use to measure using the survey that was done of the property by Jones Associates. And we can take, you know, approximate points and measure the width of that, looking at the before photos and come up with a pretty accurate number on what we believe, you know, the width of that tree could have been.
Have you done that?
Yeah.
Okay. And would you be able to walk the board through that calculation?
I could probably do that right now. Yeah. Let me just see if I have. Everything that I need. Yeah, I can do that. Does the board want me to do that?
I'm just gonna, if I can, just register an objection. I think what we need to remember here, what is relevant is what measurements were in this. What's relevant here is what was known to the code officer at the time of the notice of violation. And I think we're getting really far afield here. You know, again, much of the evidence has already been submitted. I think to Attorney Wagner's point, one of the important things to consider here is that this is not another opportunity to backfill or to supplement evidence already given. I think, as Attorney Wagner said, is that it's important to understand what evidence could have been or should have been given at the time. I mean, we're you know, I think that this should not be looked upon as an opportunity for the code enforcement officer to look in the rear view mirror and supplement the record. What's important is what was known at the time of the notice of violation and what was actually included in it. So I think we're going a bit far afield here.
May I respond?
Yes.
You don't get to eat your cake and have it too. You moved to supplement the record. It was granted, and it's only fair that Tom be able to respond to what you've put into the record. And that's exactly what we're doing.
If I may, again, I think there's a distinction between the use of this tool on site and how it relates to the relevant articles that have been entered, and a discussion about how evidence or purported facts and figures that were obtained following the issuance of the notice of violation in some way impact or cure, as it would be, any obvious defects in those notices. And I think that, if I can summarize, I believe to be Attorney Rachen's argument.
So I'm gonna, unless the chair has an objection to it, just offer my opinion here. I think that the door's been opened to questions about how measurements were made and the reliability of Alex's testimony of his measurements, and so I don't see anything impermissible about the line of questioning here. Again, I think the door's been opened for that. So those considerations of fairness and relevancy, you know, that was what should have and was considered before this was admitted, but now that it has been admitted, I think the line of questioning is fair. But I would just ask that we, you know, keep in mind the time and try to be brief about it. So that's my recommendation to the board.
I don't disagree. What I'm saying simply is this, is that we are not talking about, if we're talking about accuracy of what was used at the time, we don't need to then go and talk about, oh, and then I looked at a survey later in time yesterday after this was raised. I understand that, you know, the town has the opportunity to talk about the accuracy of the methodologies used, but then it's not appropriate to talk about what they went back to their office today after that testimony yesterday. That's the only distinction I'm making. The accuracy of the methodologies used in time at the relevant time, which was prior to the issuance of the notice violation. That's it.
Yep, I appreciate the clarification, and I think your point's clear on that. But just so that the board knows, I stand by my finding that this questioning is permissible, as you know, the parties have introduced, all the parties here introduced and relied on evidence that has happened after the violation. So I don't think that the fact that we're talking about measurements that occurred after the notice of violation was issued makes the evidence inadmissible.
Yeah, if I could
Relevance.
just add real quick, one thing on that. I can't take you guys all to the site right now and paste the site with the app to do that in real time. Fortunately, that was done then, and there's no way to duplicate that. So I don't know how we would at the moment, but we can do that now.
If I may, Mr. Chair, I'd just like to preserve and point out an issue with due process there. As CEO Soroy has just indicated and testified, there's absolutely no way to develop or recreate the results in which he's seeking to testify here. And I think that's part of the problem and issue, and what either Attorney Rachin or I's additional questioning might indicate here is that as a defendant, as an appellant in this case, we're being presented with facts and measurements and circumstances that the CEO himself has just indicated he cannot reproduce.
I guess I just don't agree, because I don't see how that's any different than me going and pulling a tape.
So can I think we're getting into a bit of back and forth. So I'm going to turn it back to the chair. You know, there was an objection from Attorney Rachin to this line of questioning. Does the chair, do you, it's totally within your discretion if you want to permit this line of questioning, or if you would like to instruct Attorney Wyckoff to move on.
Yeah, two things. I'm perfectly fine with continuing on with this, because it was my understanding that with the submission of this information and hearing from Attorney Rachin and Attorney Braun, that it's important to establish that accurate measurements were taken. So it is important to hear how Alex went through with this, and if inches really matter in these cases, or if it's you know, potentially not that concerning. And also, Alex, you'd asked if you need to go through the steps of showing the canopy. I don't think that's necessary. I think we tracked with you fine with that yesterday, unless somebody else on the board says otherwise. Again, we don't have to get too deep into this, but certainly clarification of the measurements, which I think we all think are important. Clarification of what steps were taken with regards to the measurements. It's appropriate to hear through again. So I guess we'll turn it back over to you, Attorney Wyckoff, unless Attorney Wagner thinks otherwise.
No, what I understand is you're allowing Attorney Wyckoff to continue with that line of questioning and noting that the objection has been made for the record.
Thank you. Alex, let's go back to where we were. Can you continue where you were, or do you remember where you were?
No, why don't we fire that back up?
Okay, I think I maybe lost track too. I think we were talking about the opening in the canopy. Actually, no, we didn't. I think, did we complete that? I've lost
No,
track.
that's where we were. We were on the
Okay.
canopy. You're right.
Okay, so could you just help the board to, you know, I think you said that there was another way to verify that, and I think you were gonna lead us through that.
Yes, I can do that. But you guys got to be kind, because I don't do this publicly normally. So it's going to be interesting. So let me just share this screen here. So here you can see the before photo. You know, you've got the tree next to the stairs. And if you look here, you can see that this tree that existed that we were unable to actually physically see on site hangs over the stairs, very clearly hangs over the stairs. And the stump for this tree is located at the top of the stairs. So using a scalable plan, which is derived from the survey from Jones Associates, you know, I'm assuming right now, based on the information I have, not being invited to the site to actually inspect this tree, that, you know, we've got a canopy that hangs over to the stairs here, and like I said, ends with the stump around right there. Measuring that with this scaled, measuring tool, that right there is 16 feet. And, it's clear from the photo that, you've got an area that's, at least 16 feet wide with this tree. From almost all the way over to where this deck is and back. Again, we're relying on what we have available to us here. Measuring from here over, saying that the center is around there, again, we've got close to 20 feet. And so let's say for conversation's sake, that was 20, I think it's actually 23, 16 by 20 is 320.
320,
that's
320 square feet.
320 square feet, which is, that's a pretty conservative measurement of just one, quarter of that pie squared off. So, it's easy to see just based on that there, that they exceed 250 square feet. And it's definitely a violation of that section. Now, that's only one tree. There's other sections, of this lot that canopy was open, and that one is, just the easiest one I think to see in this particular situation. But clearly it's in excess of 250.
And the document you were looking at, can you just describe what that was?
Yeah, this was a plan created by Stony Brook Consultants. Actually was used by Mike Morse when he created his first rendering of a proposed replanting plan, I think,
And
at some point along the way.
And is that at page 138 of that 249 page PDF that Attorney Rachin provided to the board yesterday?
I believe it is. I don't have that up in front of me. I think I closed that window, but I believe that is where I got that. Yeah.
Okay, very good. Okay, now, so in other words, in that one, you measured that one instance, so, and that's just one of them. So in other words, you're exceeding the 250 square feet opening in the canopy by factors, actually, correct?
Yeah, oh yeah, definitely.
Okay, so then let's next talk about a 25 by 50 grid to apply the point system. Can you explain to the board why it shouldn't be concerned about that number by these articles that have been submitted?
Yeah, and we could use that same tree for conversation's sake. That particular grid, if you were to establish a 25 by 50 foot grid in that section of the yard, that was the only tree within that grid. And even if we give it the maximum number of points, it's still only going to be worth 8 points. You can't remove any trees if you're going to have less than 24 points as the end result. So I just don't see any particular situation where you could establish a grid that would also include that tree that would give you more than 24 points. It just doesn't seem possible.
Okay, so in other words, there's many more than a single 25 by 50 foot grid that doesn't have enough points.
At least two.
Okay. Could I actually, could you go back to that plan that you showed earlier? Could you go back to that, please?
Yeah, hold on one sec. Sorry, I got too many things open here.
No problem.
All right, this one here?
Yeah, that's right. Could you do me a favor and zoom out a little bit?
Yeah.
And I just want, and there, Attorney Rachel had mentioned an issue that Chief perceived relating to the location of the normal high water line as a result of this stuff. And what I'd like you to do is, could you zoom in on the bubble that's included in this document that's already in front of the board? that relates to the location of the normal high water line, please?
Now you're talking about this one down here.
That's right.
Yeah, so this says that the shoreline was regraded with riprap between survey dates of 6/20/2019 and 11/9/2021, which changed the horizontal location of the high water line, which you can see here. The 11/9/2021 date is this line here. Sorry, I got the measure tool on. Let's turn that off. This line here, oh, that's white. And then the original shoreline is the dashed line, which they're pointing to here, which was 6/20/2019. So you can see there's areas here where the shoreline jogged back.
Now
let's
that's
go
actually
over to, yeah,
that's
I'm trying to
actually-
get over there.
okay. Good enough. Yep, you anticipated my question.
Yeah, that's just where the note is.
Right. So stop there. Stop. Now that heavy black line.
Yeah,
That's there. What does that depict?
are you talking about the one down the center?
Yes.
That's the lot line.
That's the lot line between Whitetail and Fernwood, correct?
Yep.
And Whitetail is on the right side of that heavy black line.
Yeah.
And that former normal high water line extends over the lot line and into Fernwood, Whitetail, doesn't it?
Yeah, I believe you're talking about this dash line right here.
Right.
And then the new line. Yeah.
Right. So what does that survey show you?
Looks to me as though the shoreline's been expanded.
Okay. And you didn't need to have any Google apps or Measure app to figure that out, did you?
Correct.
Okay. I don't have any other questions. Thank you.
Yep.
So I would turn it over to Attorney Rachin as the appellant to ask any questions of Alex.
Sure, thank you. So back to, what I'm trying to think the whole point of this submission of this article was to talk about the accuracy of the measuring tools that the CEO said that he was using at the time to establish that there were violations. And so with that in mind, Alec, what version of the iPhone measuring app were you using?
I'm not sure.
Okay.
Whatever version existed back then.
Okay.
I don't know particular.
All right. So you're not sure, but how recently did you update that app on your phone?
I am not sure. It would have been last October. I don't, it's a year later. I don't know what version we were using at that point in time.
And did you ever upgrade it or did you just take what was on your phone and use that?
I update my apps daily. If there's notification for updates required. So it would have been whatever the version was at that particular date.
Okay. And in your testimony, I think I heard you say that, the protocols that you use, how much you move or, what time of day, those kinds of things are critical to the accuracy of the measurements. Is that correct?
Yeah.
Okay. And do you recall what time of day it was that you were using this app?
It was midday. I think it might have been late morning.
Okay. And how did you ensure that you were, I think you said you can't move that fast, or, do you have any recollection, or did you note how fast or how you were using that app?
Yeah, used it as I normally would.
Okay. And I think in the article, and you may have even said this yourself, that you need to take, in order to ensure accuracy, multiple take those measurements multiple times. Did you do so?
Yeah, we did multiple measurements. Yeah.
I mean on your phone app while you were doing the measurements, just to be clear.
Mm-hmm. Yeah.
Did you take?
I usually go from the water up and then from that point back to the water.
Okay, so when you say
so
multiple
usually
times,
always two.
Twice. Okay. And while you're doing that, in order to have records of that and to record it, did you take sort of screenshots, or how did you record your multiple attempts at measuring?
I just noted it
Where?
in our logging system, our note system that we have, just a notepad.
And when you say notepad, is that something, when I'm old school, this is my notepad. Are you saying you had like an iPad that you recorded that in?
No, just like to be honest, a lot of times I'll text myself if I'm, in a situation, but I usually will do voice notes because it's just not, and try to send a text in the rain, for example, it usually is pretty difficult. So I'll usually do voice notes.
Sure. And so you maintain those records? Do you keep those records?
I'm not sure if I have any specifically for that. I know, a lot of our mission the day that I went out initially wasn't necessarily to, be getting specifics on dimensions and stuff like that. I mean, also we need to remember things like the boat ramp were gone. I mean, there was a lot of things that, we really didn't need to measure necessarily that first day we went out. It was more or less to assess the violation. Now, when DEP went out, they did take more specific dimensions, and Jeff did actually log that information, I believe, on just a notepad. And I know Chris has some notes on a notepad as well as far as dimensions go.
Okay. And let me just follow up on that question. When I just want to be clear, I said this initial day when you went out, and you said that you weren't thinking necessarily of taking precise measurements. And when you drafted that notice of violation, were you going off those measurements that you took that day?
Well, we had been to the site multiple times when the NOV was issued.
Okay, that's fine.
By the time the NOV was issued.
Okay, and one other question I had for you is the document that you were showing, that Stony Brook survey. I noticed that you were using that tool and had various scaling and such. What was that program that you were using?
That's just Adobe.
That's Adobe.
Yeah.
Okay. And did you have any particular training in Adobe to be able to do those kinds
Yeah.
of methods?
Yeah.
What was that?
I took multiple courses in digital media using various Adobe Suite products in college.
All right, thanks, Alex.
Yep.
Attorney Braun, I would give you an opportunity.
I think Leah touched on most of the things I was going to ask, but just to ask a few extra. Alex, you testified there that I believe your exact words were "little things can affect it." That's a quote. And you pointed out fingerprints can affect the accuracy of the measurements you take with that device. What sort of steps or protocols do you use to speak to that, or make certain that measurements are accurate?
Yeah, it's a great question. I think would be, if you guys all tried it out tonight, if you have an iPhone, it's probably would probably enlighten you a little bit on how it works. So it uses your phone's camera. So it's very easy. If you hold up your camera and it looks blurry, it's smudged. So you just wipe it off. That easy.
Okay, but you do understand that the specific phone and the specific app that you used or what is relevant in this matter, correct?
Sorry, you cut out a little bit. I didn't hear you there.
Sure. So you invited us to try it ourselves at home, but you do realize that the specific phone and the specific app you used are what's relevant to this, right?
Sure. But I mean, everyone needs to understand the information, specifically the board members.
Okay. You said that when you went out and did the measurements, you did it as you normally would. Do you have a written process or protocol that you follow when you go out to these sites?
No.
Okay. As it relates to your note keeping, you said sometimes you send voice texts, sometimes you send or voice notes in this case. Is that correct?
Yes.
Okay. And in fact, you're not certain what sort of working notes or on-site notes may actually exist as it relates to your evaluation of the property. Is that?
Yeah. No. I assume you're specifically talking about October 26th, and the goal for October 26th, like I said, wasn't to go out and get all of our specific dimensions and stuff like that. It was literally to meet with Rob Durant on site to say, dude, what happened? Sure. And that was our mission there.
But you did also give orally a stop work order on that day, correct?
Yeah.
And so you would have then had to have made some determination that a violation took place to substantiate that oral stop work order.
Yep, but we didn't, serve a notice of violation on that day, as you know.
And you didn't follow that up with a written stop work order afterwards, correct? Just to clarify.
Correct.
Okay.
Correct.
Do you recall, you said it was sensitive to light. I don't want to belabor it, but just for the record, do you remember what the weather was like on the 26th when you went out?
Yeah, it was cloudy. It was overcast.
Okay. And how does that affect the accuracy of that measuring tool?
It worked fine.
Okay. And what history or examples can you compare that to say it worked fine?
I mean, I've been using it for, I don't know, 3 or 4 years at this point, long before I was in Raymond. So I would compare that to previous uses. I mean, there's times if you use it in the dark, you're going to tell it's not working correctly. So I wouldn't use it if that were the case.
All right. And finally, the device that you're using, is that town issue? Does that belong to the town or does that belong to you personally?
Belongs to the town.
Okay. And do you use it for personal purposes as well?
Nope.
Okay. No further questions.
So do we have any members of the public who have any questions for Alex? Sorry, Mr. Soroy. Seeing none, I'd turn it back to Attorney Wyckoff. Do you have any re-examination?
No, not necessary.
Okay. Does anybody have any further comments from the attorneys? Oh, I'm sorry, actually, does the board have any questions for Mr. Soroy? I'm not seeing any. Did any of the attorneys have any closing arguments to make? I think we've covered everything on this point, but providing that opportunity, not seeing anybody taking it up. So I would suggest to the board that we close the public hearing and the record again.
So we need a motion for that, correct?
Yes.
Yeah, so moved.
Attorney Wagner,
Seconded.
just to confirm, do you need to have it open or offer a comment from the public for this reopened evidence? Just again, making sure we're.
I gave an opportunity for the public to speak. I guess yeah. Let's just act consistent with past practice. How about, can I have a motion to reopen the public hearing? Can I get a so moved on that?
So moved.
And can I get a second?
I'm sorry, I'm confused, to be honest with you.
Second.
So what I'm doing right now is just reopening. In the past, we've had a practice of making a motion to open the public hearing and then ask if there are any public comments and then close that. And so I think Attorney Braun raises a valid point that we should go through that practice again so that it's clear that the public was given an opportunity to respond. So we have a motion and a second to open the public hearing. Can we do a roll call on that?
Sure. All in favor, David Murch, yes.
Greg Dean, yes.
Fred Mello, yes.
Henderson, yes.
Pete Lockwood, yes.
Okay, so that's unanimous. Any comments from the public? Seeing none, can we have a motion to close the public hearing?
So moved.
Second,
And roll
David
call.
Murch, yes.
Greg Dean, yes.
Fred Mello, yes.
Henderson, yes.
Pete Lockwood, yes.
Fred, I think we're waiting on you.
Fred Mello, yes.
Okay, and so now I would entertain a motion to close the record.
So moved.
Second,
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mello, yes.
Pete Lockwood, yes.
Okay, so the record has been closed. That additional material and testimony is now part of the record. So now we would proceed to deliberations. I don't know if I'll defer to the chair if you want to call a break in between now or if you're ready to dive into deliberations.
Yeah, given we're hour and a half in, let's take a 5-minute, 5-minute break and then return and kick in to those. So 7:37. So Attorney Wagner, you've been good to walk us through these from a procedural perspective. If you could do so again, that would be greatly appreciated.
Sure. So the board's now entering into deliberations on this appeal. As before, I suggest that we have in front of us with these documents that I'll be using, and encourage the board to use just to help guide us as the notice of violation for this appeal, the notice of appeal filed by Management Controls, as well as the town's proposed findings of fact and conclusions of law. As you'll recall, in the past, we've sort of used those 3 documents to guide our decision process and then consult, evidence as we go through it. As before, I suggest the board, we go through issue by issue and make a tentative vote on each issue and articulate the factual findings of the board. As before, I'll sort of take a consensus on the factual findings, and that'll help me write up that decision that we'll vote on. So again, those votes are tentative. The final vote will be based on the draft written decision that I'll present to you at a subsequent meeting. And at that time, we'll take a vote, and that will be the final decision. So I again suggest that we, as we go through, identify the applicable standard, review the arguments on both sides, get a sense of where the board is on, whether that particular violation should be upheld or vacated, and go through the analysis there. So bear with me a second. So as I see it, the first initial issue is whether all violations should be vacated because Management Controls reasonably relied on its contractor to obtain all required permits and act consistent with the shoreland zoning ordinance.
I'm sorry, can you repeat that? Yeah.
Sure. So I think the first issue to address is the argument from Management Controls that all violations should be vacated because Management Controls reasonably relied on its contractor to obtain all required permits and act consistent with the shoreland zoning ordinance. So, Chairman, you're now you're back.
Okay. Yeah, I'm just looking to get some insight from my fellow board members.
Yeah, one second. I'm reviewing the actual. We've accrued quite a few documents at this point. Yeah, I mean, I thinking with respect to the reliance on the contractor, I think it's doesn't really invalidate the NOV. I think I don't know if it's even our role to unwind the accountability to that degree. So I sort of think the town's position is correct here. What's everybody else's thoughts?
Greg. I believe the town is, as shown. Tom, anybody else? Pete, Fred?
I agree. I think the town has demonstrated that the owner is responsible.
I agree with this as well.
It smells like poop now. Is he farting?
I agree. I think the town is
You don't smell you out.
He's talking. I'm sorry, got a little distracted there. Was that you were just talking, Fred?
I said I agree. I agree. with
Okay.
all. Yes.
So I'm sensing the board is unanimous in that. Can I ask, so previously in the management controls decision for 18 Fernwood, the board made factual findings here that I'll just briefly summarize. And my question is going to be if those same factual findings and reasoning that you applied when this issue was raised there apply here. So actually, I won't even summarize. Let me see if I can just get an answer to that. Do you agree with the same findings you made in that case and the same reasoning for that you gave for why the argument here you were not persuaded by, and you believe that management controls is liable for actions, or rather, the fact that the actions were conducted by management controls agent does not invalidate the violations?
Yeah, I agree with that.
Okay.
I agree.
I
with that.
agree.
So the only difference being, of course, that here you're dealing with 28 whitetail. So your findings would be that the MCL is the owner of 28 whitetail, and that they contracted with either Durant Excavating, Marine, and or Robert Durant to obtain all permits and perform the activities giving rise to the notice of violation at 28 whitetail.
Yeah.
Okay. So I'm sensing unanimity on that finding. So I would suggest a motion concluding that the board concludes that MCL is responsible and the CEO did not err in all violation. Well, that's on the negative. So how about a motion to deny a motion to uphold, a motion to deny the appeal on the grounds that all violations shall be vacated.
So moved.
I'll second.
Favor David Murch. Are you hearing?
Yep.
Okay. Gotcha.
What's up?
I think
Yeah.
we're
Roll
going
call.
a roll call vote. Yep. In favor, yes. David Murch.
Yes, Greg Dean.
Tom Hennessy, yes.
And Miller, yes.
Pete Lockwood, yes.
Did we get everybody on that? Okay. So the next issue is whether violation 1 should be vacated. I'll summarize that this relates to soil and water conservation practices in this zone, which may be conducted without a permit, and the applicant's position is that there was, sorry, just catching up on my notes here, that the town had presented insufficient evidence that this violation occurred. So again, my suggestion is that we identify what was raised in the notice violation, the applicable standard, and make your findings and conclusions based off of the evidence presented on those issues.
So the notice of violation, filling and earth moving of more than 10 cubic yards, but the shoreline zoning positions was specific to erosion control. Section 15, land use standards, section U1, erosion and sedimentation control, filling, grading, lagooning, dredging, and earth moving. And all other land use activities shall be conducted in such a manner to prevent erosion and sedimentation of surface waters to the maximum extent practical. All activities which result in unstabilized soil conditions and which require a permit shall be developed in accordance with an erosion and sedimentation control plan prepared in conformance with the requirements of the Maine Erosion Control BMPS, Bureau of Land and Water Quality, Maine Department of Education and Environmental Protection, March 2003, and subsequent revisions thereof. So we're looking at erosion control. And I believe it was presented that no erosion and sedimentation control plan was prepared or submitted. We did see pictures that indicate that what erosion control was in place. Some of it was down. I don't see that this particular item was in error. I think it's correct. Anyone else?
I agree with you. The pictures was showing that that it was laid down, you know, by the boat landing area there.
I agree as well, David. I think there were some pictures that even showed some erosion.
So one of the threshold findings here, and I'm going to just read from the proposed findings on this issue, is that filling and earthwork of more than 10 cubic yards took place within 100 feet of the normal high water line of Sebago Lake. So I'd ask the board to give me your thoughts on whether you think the evidence supported that finding. And I think it's important to point out here, you know, what evidence you are relying on to make that conclusion.
Yeah, I think that's, I'll take a swing at this. So I think that the whole, well, I guess there's two parts. There's one is the measurements that have been demonstrated. Did they exceed the threshold? And from the visual evidence that's been displayed, and there's the pictures of the riprap that's been added, or sorry, the beside the house that has the vegetation removed, all sort of exceeds the threshold based off from the purported measurements. And then I think as a secondary measurement, hey bud, hold on one second, daddy's talking. And as a secondary point there is the quality or the accuracy of the measurements. And I think that I find that the threshold is the degree to which the earth has been removed doesn't come close to any of the kind of demonstrated counterpoints on the accuracy. So I guess that's kind of the twofold issue here. But I think that that's what Ms. Rachel had asked us to specifically address. So we'll do so and say that we considered at least I considered the possibility of error in the measurements, and don't find that it would, even if you take the face value of what the appellant is saying is the maximum error, it puts it within a reasonable tolerance that would fall underneath that threshold. Is that not very concise, but sorry, that's kind of.
No, I think you articulated that well enough for me to follow. So does the board agree with that finding?
I agree.
I agree as well.
I agree.
Can anyone hear me?
Yes.
Okay, good. I agree.
And do we agree that a permit was required and no permit was obtained?
I think that falls more under number 2, but although
Well,
I do,
if a permit was obtained, then they would have had to have done the sedimentation and control plan. So I think
Gotcha.
that's relevant.
Yeah.
Yeah, oh,
Understood.
yeah, good point.
no permit.
Okay. So I think I've got clear factual findings. So I would suggest a motion to deny the appeal as to this argument and uphold violation 1.
So moved.
I'll second.
David, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Steve Lockwood, yes.
Okay.
So, third item, number 2, on the notice of violation, filling in earth moving of more than 10 cubic yards without a permit. Filling in earth moving more than 10 cubic yards occurred in LR2 zone without a permit from the code enforcement officer. Looking at shoreline zoning provisions, section 14, table of land uses. Item number 30, filling and moving of more than 10 cubic yards. Yeah, we recognize, at least I recognize that a permit was not obtained, and as discussed, more than 10 cubic yards was moved.
Yep, I agree for the same reasons, including accuracy of measurements, but when it comes to the threshold. Yep.
Okay, so what I'm hearing is same reasons and findings that applied in 1 apply here.
Yes.
Okay. I think it makes sense to also address here the argument that 2 and 1 are duplicative and should be consolidated. Do we want to address that now?
I look at this, I've presented here 2 separate items of the shoreline zoning provisions. One is very specific to filling and earth moving. More than 10 cubic yards, or the other one, while that does include filling and earth moving, it's also specific to an erosion and sedimentation control plan. And so I find them to be separate items. At least that's my perspective.
Does anybody disagree?
No, I agree.
Nope, I agree.
I agree.
So I think what you articulated is consistent with the board's reasoning on this issue when it was raised as it pertains to 18 Fernwood. Would you agree?
Yes.
Yes.
Okay. So I think at this point I would suggest a motion to deny the appeal as it pertains to this argument and to uphold violation number 2.
So moved.
Second.
Good Merch, yes.
Greg Dean, yes.
Fred Miller, yes.
Tom Hennessy, yes.
Steve Lockwood, yes.
Okay, that's unanimous. So the 4th issue pertains to violation 3. I'll turn it over to the chair.
Here's docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland without a permit from the planning board specific to the boat launch. Boat launch has been enlarged or expanded at or below the normal high water line of Sebago Lake without a permit from the planning board. Shoreline zoning provisions, section 14, table of land uses. Item number 17B. permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. So this is definitely in the LRR2 district. The question is, do we have evidence supporting that the boat launch has been enlarged or expanded?
I'll take a swing at that, David.
Sure.
Yeah, I find the evidence pretty clear, given the comparables beside the boat launch and the visual evidence. It looks like it was expanded substantially. It also looks like that expansion falls to the degree at which the error would have been. Again, if you take the maximum error, it would not reduce the expansion kind of below where it would need to be in width. So I think we're talking like 8 feet to 16 feet. And I don't see anything that was presented that would make that a meaningful amount of error. You'd have to lose a whole 8 feet for it not to be expanded. So I think there are multiple ways of measuring that, and kind of I think it's pretty clear from the visual evidence that it was expanded.
Yeah, I would say, I would agree. I would say based on the visual evidence, testimony from Alex, and also the information that we received in that large PDF document about,
Yeah, that was Exhibit B.
yeah, specifically page 127 of the PDF, where it says contractor one has stated that the boat launch structure was widened by approximately 6 additional feet in the southerly direction after removal of a large tree stump immediately to the south. You know, but I'm not relying on that alone. Again, both visual evidence and testimony by Alex would lead me to believe that yes, the boat launch has been expanded, and I would also say that there was no approval from the planning board to do that.
I agree.
I agree as well.
I agree.
Okay, so what I'm hearing is you find that there's no record of a planning board permit for the boat launch. The boat launch was enlarged, expanded, and replaced, and that this was done without a permit, and that this work therefore is in violation of section 14 at line 17B, as well as shoreline zoning ordinance 12C4. Is that accurate?
Accurate, yes.
So if you can bear with me, I just want to check my notes on the other arguments that were raised on this issue. So, and as the board had considered, the appellant made an argument that, you know, this was a non-conforming use, and it really wasn't replaced. There was just, I guess I would characterize it as a modification with similar material to the shoreline, and it was a minor modification of an existing non-conforming use. Was the board at all persuaded by that argument? Any additional findings or reasoning concerning that argument?
I'll take a shot at that one. From the photographic information, it looked like, as Alex presented also, there's a few pallets of wood and some planks to hoist in small kayaks and dinghies. And the after effect is now a very large, long riprap boat launch that vehicles and trailers can now go and launch their boats. The former one was just a homemade little plank of wood to throw in small boats. So it's completely different.
I agree with that.
I agree also.
Yeah, I agree. And I think also I didn't see evidence of a tree stump being the cause of anything as well. I think I'll point out that I saw no evidence of that. I believe is also a point that was made.
And I'll add to that, Greg, that the tree stumps aren't supposed to be removed. On top of that, that's another violation.
And Greg, I think you already touched on this, but yeah, you did about the location of the normal high water line and whether the dispute about its location affects your findings at all. I think you said same reasoning as you have before. The margin of error is so small here that it wouldn't affect your findings.
Well, with the normal high water line on this particular issue it's about where the so it's about where the enlargement or expansion occurred, right? So I'm not sure if there's a measurement that was debated, at least in this particular instance, other than with it being within inside a certain distance to the water line, maybe. But
okay.
Maybe I'm not understanding the.
No, I think I think I understand what you're saying is that the I guess how I would phrase it is that where the normal high water line is or is not really relevant here as to what's key as to whether the boat launch was expanded or enlarged, and you feel the evidence clearly establishes that, and so that finding's not altered by the debate about the accuracy of the measurements used.
Yeah, I can clarify. I can clear that up in my own words if that is helpful. But that's a fair summary. I think that there's the water line can move up and down within a certain band, and if no matter where the water line was, it looked like the expansion would have still fallen within the sorry, it would have still fallen in violation.
Okay.
So that there's no issue of a tolerance that would have moved it outside of the violation, I guess.
That's clear. Thank you.
Yeah, and I don't. Yeah, okay. I'll stop there.
So those findings support a conclusion by the board that the violation site of the ordinance cited in fact occurred. Is that right?
Yes.
Yeah, I agree.
Okay, then based on those findings and conclusions, I would suggest a motion to deny the appeal as it pertains to this issue and uphold violation 4, right? 4.
So moved.
Second.
David Murch, yes.
Wait, no.
Lockwood, yes.
Tom Hennessy, yes.
Ed Miller, yes.
So that was unanimous, but I think actually it is violation 3. Sorry.
Oh, I'm sorry. Yeah, you're right.
Let's do that again, but in violation 3, sorry.
So moved.
Yep.
Seconded.
All those in favor? David Birch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
All right, thank you. Sorry about that. So now 5th issue, which pertains to notice of violation 4. I'll turn it over to the chair.
So piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or above the normal high water line or within a wetland without a permit from the planning board. This is specific to the shoreline. Shoreline has been enlarged and expanded without a permit from the planning board. Looking at shoreline zoning provisions, section 14, table of land uses, item number 17B. Permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. So this is definitely in the LRR2 district. I guess the question that I have is shoreline. Is that, do we view that as a structure? Do we view it as other uses? Or does it not fit either one of those categories?
I think when Alex was speaking, that he was saying that the riprap that was put into there was increasing to the shoreline or the structure, enlarging that where there didn't seem to be any erosion there, so that there was no reason to have had to build up onto that area.
Yeah, I think this is with the S that cuts in, and there's been fill to kind of straighten it out, expanding the shoreline. My understanding is that the threshold is 0, and it certainly looks like that was exceeded by a substantial amount.
So can I actually walk it back a little bit to where I think it was Chairman Murch began this with what I think is one of the legal arguments that was raised of a shoreline is not a structure, so an enlargement or modification of the shoreline could not violate this section of the ordinance. So I think the board should address that first, and then if it concludes that an enlargement of a shoreline can violate this section of the ordinance because a shoreline is a structure for purposes of these ordinance sections, then we get to the factual question of was it enlarged or was it modified?
Yeah, that's fair. So I think it's a use is what we were interpreting as that part of the ordinance. And in particular, I believe it's a boat launch.
No, we're looking, actually, boat launch was addressed in number 3. The shoreline is we're looking at for number 4, essentially the exact same item in the shoreline zoning provisions, but this is specific to shoreline
Expansion. Yeah, but
yeah.
isn't that S, wasn't that cut in at the boat launch? Wasn't that S that we're talking about?
I do believe so, yeah.
So the use, I'm saying this, in this particular case, it's not just a random piece of shoreline. It's a use of the shoreline. And that for better or for worse, that's what the ordinance says, right? Like it says use.
I don't know.
Open to other comments. Speak of that, but
I'm trying to remember, but I believe, didn't we hear that was actually that riprap was considered a structure?
That's what I believe as well, Fred. I want to say I thought I heard Alex refer to a retaining wall and that construe as a shoreline. So that's the definition they were using, if I remember correctly.
The structure, correct.
I see.
So the question is, do
then
we agree with that definition?
That riprap is a structure?
That shoreline ultimately is a structure.
I think if you use the shoreline as a boat ramp, it's a structure. Like if you put something on the shore to launch a boat, like previously would have been considered a structure with pallets. Is that like, so I mean, that seems like a structure.
Yeah, well, I would agree, but this is part of.
We can't hear you, Dave.
So if you go back on this, it mentions boat launches separately.
Mhm.
So boat launches and other structures. So I understand what you're saying, Greg, but if we review to that portion as boat launch, then we've already addressed that as part of number 3. Did you kind of see what I'm saying?
Oh,
So
are you saying that they could be duplicates?
Well, because if we use the argument that the shoreline well, I guess you're saying it's a use. I guess I have a hard time because we're looking at this as a use for the boat launch, but boat launch was already addressed. So then it seems like that doesn't. I mean, we already talked about that part of it.
That's a fair point. I mean, I think the strongest argument there is that it's a structure and it's a boat launch, it's a boat ramp. And then if that's the case, then it's already covered by 3.
Right. Anything you want to add to this?
I'll just comment. I think that the basic premise is adding fill to the lake to increase your property line is as simple as you could put it. If you continue to add more and more fill or riprap or whatever, eventually you'll get a jetty protruding into the lake. And I think that's what we're discussing here. Was there additional material put in the lake to extend you can call it the property line, but whatever. So that would be my point on this.
Again, I don't disagree with that, but can we use that as a definition of a structure?
Well, not if it's clearly itemized as a boat launch. I don't think so. I think it's a boat launch. Like the other structures would be if we were interpreting some other nebulous thing, but given that I think the ordinance states boat launch.
So maybe it makes sense to, why don't we take a look at the ordinance? So I think we're dealing with section 14, line 17B.
Yep.
It seems to me that we're trying to define what the other structures are. And it definitely looks to me like the riprap that was added between the boat launch and the stairs above the beach is additional structure.
And is a structure? Or are you looking at it as structure in association to the boat launch or structure in association to what?
Beyond the boat launch. It looks at from the pictures that Alex provided, this significant riprap added beyond the boat launch towards the stairs above the beach.
So let me just gonna provide some things for it's your decision to make. I just want to provide you some, additional guidance. So just, page 65 of the ordinance has definition section. So the board could consider definition. We discussed the definitions of structure. in there, and both parties did on that to make their arguments for why a shoreline was or was not a structure. And also remind you that the town relied on the arguments that it made and suggested that the board should make its decision consistent with its decision on 18 Fernwood. So if you look back at your decision on 18 Fernwood, I believe it was violation 5 pertained to the expansion of shoreline, and the board concluded that the shoreline was expanded and that violated this section. So I think implicit in that finding is that the shoreline is a structure. I acknowledge, however, on the other side is that we're talking about two different shorelines. So there are entirely different facts. So I'm just putting those additional pieces of information out there to help the board wrestle with this threshold question as to whether the expansion of the entire shoreline there can be a violation of line 17B.
So,
I still believe it's a structure, Dave, that Alex brought up, that is a structure. It has, as Tom said, it is added, structural to the property front of the property there by the water. I still feel that, it is a structural piece of the property.
So our definition of structure is anything temporarily or permanently located, built, constructed, or erected for the support, shelter, or enclosure of persons, animals, goods, or property of any kind. Which I don't think that matches, but I think it says together with anything constructed or erected on or in the ground. The term includes structures temporarily or permanently located, such as decks, patios, and satellite dishes. Structure does not include fences, poles, or wiring with their aerial equipment normally associated with service drops, including guy wires and guy anchors. Subsurface waste disposal systems as defined in Title 30A, geothermal heat exchange wells or other wells. So right here, structure, I can see anything constructed on or erected on or in the ground. I could potentially see something, and as Tom had said, it's been built up. I think Pete was alluding to that as well. So has something been constructed there beyond a boat launch?
I mean, if we look at Exhibit 3, Exhibit C and Exhibit 3, which I think is on page 56, it almost looks like there's a wall that's been added there.
Yeah, and I think that's was part of Alex's comments.
I mean, it looks like a full wall that's been built. I mean, it's definitely a structure. I believe that's on page 56. There's a before and after. It's actually for the beach. It's showing the beach, not the riprap. But if you look at them two pictures, there's definitely a wall been added there.
And I'm pretty sure, based on my recollection, that is consistent with what Alex had been talking about.
But isn't that part of the boat launch?
No, I think that's a separate structure, Greg.
Okay.
It's closer over to.
Well, I guess it would be. It's near there though. No, I don't. I think you go down another picture. You go down one more picture. No, you're right. We're over farther. You're correct.
Right. Definitely over further.
No, you're correct.
So let me ask this question, which I think is what we're getting at, but I'm not quite following. Do we think there has been enlargement of the shoreline in any area besides the boat launch?
Yes, I think so.
Yes.
You do. Okay. So I'm going to throw this out there and I just want the board to consider it. So I have notes in my from here that during the CEO's testimony, I think during Attorney Rachen's questioning, he was saying that the only part of the shoreline that was expanded was with respect to the boat launch and nowhere else. So I don't know if the board agrees with that. Do you think there was different testimony? I just wanted to throw out there that I took note of that.
I have the same note actually, and I'm also not able to locate where, if it is, where it would be, but I'm admittedly, maybe I'm looking at the wrong page 56. I think Fred, you said page 56, but
Right.
I'm not sure I mean, unless we did disagree what the testimony was. I mean, I believe that was his testimony. So I'm not even sure if Alex would refute the fact that we should be focusing on the boat launch.
Correct. Which has nothing to do with a page 56. I was over too far.
Yeah.
So I think I'll throw this out there that if you find that the only shoreline that was expanded for 28 whitetail is the boat launch, then I think that leads you to the argument that this is duplicative and there's not an independent violation for an expansion of a shoreline, because the only expansion here was the boat launch, and so that's covered by violation 3.
Yeah, I'm gonna have to go with that. I don't have enough evidence before me to say otherwise. I think it got expanded a little bit beyond the boat launch, but I can't, I won't hang my hat on that one.
Yeah, I think I'm going back to the town's points on why trying to interpret them and see if they could be separate. I believe one is for the construction of a boat launch requires planning board approval and a permit for a boat launch. And then there's some allowances of whether or not it was a consideration, I guess you need to take into fact of whether or not it was a existing structure there. But I think you still need a permit. And then 4 is for because you could basically construct a boat launch, but not, contrary to what some of the perhaps other duplicative issues, like I think you can uniquely violate these. You could construct a boat launch and not expand the shoreline, and you could expand the shoreline and not construct a boat launch. So my understanding is that they are addressing unique aspects of the same activity, but fall under different ordinances. I'm open and to feedback on that, but.
So just I'm just weighing. I think that's a very good summary of the town's response to that testimony, and so that's sort of the counterpoint there.
So is it fair to throw out there as a proposal that it's a boat launch and it was expanded and they're not duplicates? I think that's
Sure.
where I'm looking, is that the boat launch seems like it is captured in both violations. They seem to address different aspects of it. I think the town's provided sufficient evidence of it. And to address the measurements, I do not think that the issue is within any tolerance of error that has been presented by the appellant. That's my take.
I agree with Greg, I think.
And is it fair to, if that's the board's finding, is it fair to say that that's how you get around that issue of is the shoreline a structure? Because you're saying, look, it's a boat launch area and that, I guess you still do need to, let me, I'm sorry, not inserting myself. What do you, does that reasoning, I mean, can you articulate where we are on this issue of the shoreline itself can constitute a structure such that an expansion of the shoreline, whether it's part of the boat launch or not part of the boat launch, is a violation?
Well, I believe the ordinance requires a permit for expansion of the shoreline for boat launches as well. I don't think you have to use the interpretation that it's a structure. I think you can say it's a boat launch that was expanded. And that's the violation.
Okay. I follow that.
And if somebody wants to pull up and read that section of what's covered in that ordinance, we can really drill down on it, but I think we did.
I think you did. No, I do think I understand it. So I think that your reasoning is, well, as I understand it, you're essentially saying that the violation should be upheld because the expansion of the boat launch is also an expansion of the shoreline, and that violates 17B because no permit was obtained.
Right.
Okay. Does anybody disagree with that? Okay, then I would suggest a motion to deny the appeal on this issue, uphold, let me get it right this time, violation 4.
Yeah, so moved.
I'll second.
Second,
In favor, David Merch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
So the next issue pertains to violation 5, and so I'll turn it over to the chair to summarize that.
Sure. Construction of a beach without a permit. A beach has been constructed without a permit, referring to shoreline zoning provisions, section 15 land use standards, item O. Beach construction. Beach construction on any great pond shall require a permit from the Department of Environmental Protection. Beach construction on any river, stream, or brook capable of floating watercraft shall require approval from the Department of Environmental Protection. So my item here that is this actually been a construction of a beach? I have a hard time with that. I mean, I think there's a pre-existent beach. Perhaps there was some work done on it, but I don't, whatever work that may have done, I kind of look at it more as if there was something done, it doesn't necessarily, and that was a violation. It doesn't fall under this particular violation. I just have a hard time looking at this as beach construction when a beach was already there. I don't think you can maintain something, but I don't think you can consider this a newly constructed beach, but that's kind of my take on it.
The thing that I have onto this is, again, I'll go back to that page 56, is where it shows the before and after, where you do see the rocks and they're gone. But what was more interesting was the picture that was shown to us yesterday as the rocks were back as of the day before. So I I guess one of two things had to happen. Either the rocks were removed and put back, or the rocks were still there and were covered with sand. And as they brought up into the testimony yesterday, there's not enough sand in front of where the beach is to have the water wash that sand in.
Yeah.
So I
You
mean,
want-
something, you know, at some point, you know, that became a rockless beach that, you know, you definitely walk on a lot better than you can before. So one of two things I feel had to happen. Either the rocks were removed or we had sand put over the top of them.
So
Can I chime in?
are you saying that? And any sort of maintenance of the beach would you would consider as beach construction?
Well, I mean, obviously, I don't say obviously, but the area appears to be, you know, cleaner and larger in the after picture than it does in the before. I mean, if I hadn't seen the picture yesterday with the rocks being back there, then might have had a little bit harder time.
I don't disagree with you on those, but do you view this as beach construction?
If nothing else, it's beach maintenance.
Right.
And I believe in order to do beach paint maintenance, I believe it needs a permit, right?
Well, I think that doesn't really matter at this point because what was cited by Alex was section 15, which I just read, which is not specific to beach construction.
Yeah, can I say a couple things, David?
Of course, yeah, please.
Yeah. Yeah, I think unlike a lot of the other issues, like this is a little bit more of a, it's not a binary issue. It's not like the tree was either cut down or it was not cut down. You know, beaches are very dynamic things and you can capture them at different points in time. There's not a great definition for a beach anyway, and it's something that has been brought up. I think that there's a little bit of a higher threshold here. And I tend to think that the argument's pretty compelling that beaches change. I haven't seen a very strong indication that it's changed so much to think that it was constructed or even really maintained for that matter. I mean, I know there's lots of things that can move sand, waves, ice, storms, you know, like they do change. And so I find it fairly compelling that this was not the construction of the beach, and that you know, I'm more in favor of interpreting this as that it was not a violation.
Yeah, I'm inclined to agree with Fred in that it's kind of confusing when you look at Alex's presentation. There's a significant difference between the before and the after, and then the more recent pictures that are part of the PDF. It looks like it's starting to return back to the before picture, but it's still, I don't believe, as rocky as what the original pictures in Alex's presentation show. So there's definitely something dynamic happening there. And I don't think it's just Mother Nature. I think that somebody's working that beach.
So I think we've got a division on the board here. So what I'm going to suggest is that we have a motion, and then once you know that motion passes or fails, I'm going to have the majority articulate their findings so that I can reflect the findings of the majority on this. So how about a motion to grant the appeal in part and vacate violation 5?
So moved.
Okay, so everybody's clear. A yes vote is in favor of the appellants here.
to sort of reiterate? Is that what you think, Attorney Wagner?
Sorry, I didn't catch the first part of what you said.
Oh, sorry, are you looking for Greg and I to reiterate our points? at this
No, I'm
point?
looking actually, let's take a vote on this.
You
Okay.
need a second.
Yeah,
I seconded. You might not have
Okay.
heard it.
No, we didn't, David, or at least I did.
Okay,
so let's take a roll call on this.
so all those in favor of vacating, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mullin, no.
Lockwood, no.
Okay, so we have 3-2 in favor of vacating that. So can I have the majority here articulate again the reasons for that? And this is what I'll include in the decision.
Explained it, Greg, so I'm have
You are-
you, if you don't
yeah.
mind.
I can
think that was good.
feel free to supplement if you feel like I'm missing it, but I think our point of view is that the beaches are inherently dynamic. There's kind of not enough substantial evidence presented to indicate that a beach was constructed, and I think that's probably enough. I don't know if we need to have more, but I don't want to embellish it. But
No, I think not enough evidence that a beach was constructed, and 15.0 specifically is what was cited, and that requires beach construction. Therefore, there was no violation.
correct.
So that is sufficiently clear to me. So I will write that up. So I think we can move on from here.
So item 7.6 in the notice of violation, removal of vegetation less than 3 feet in height. All existing vegetation less than 3 feet in height, including shrubs and ground cover, has been removed within the 100 feet of the normal high water line of Sebago Lake for a majority of the lot's shorefront. Remove vegetation was stabilizing the segment of the shoreline and protecting water control. Shoreline zoning provisions, section 15, land use standards. Item Q, clearing or removal of vegetation activities other than for timber harvesting. Section C, in order to protect water quality and wildlife habitat, existing vegetation under 3 feet in height and other ground cover, including leaf litter and forest duff layer, shall not be cut, covered, or removed, except to provide for a footpath or other permitted uses as described in section 15Q, paragraphs 2 and 2A above. Well, I would say, based on evidence provided, that there was vegetation less than 3 feet in height removed. And for clarity, Alex did indicate that his wording of all existing vegetation was not correct. It was not all, but that all was not specific, didn't have to be all to fall under this shoreline zoning provision.
Yeah, there's no, it's not like removing some would have been okay, is my understanding. I also will add that I think that there was pictures of growth from, I guess, as recent as this week. And I think that I interpret that evidence provided by the appellant to just indicate that because the operations was stopped, it regrew and kind of the code enforcement did its job. I mean, you can cut down vegetation, it can regrow, but that doesn't mean you didn't cut it down. So I think that there was a particular picture that the appellant provided, and I think that's how I interpret that, at least.
I agree with Greg.
Yeah, I would agree as well.
Any evidence that a permit was obtained?
No permits. Do we want to address the duplicative nature of 6 and 7 now, or we wait till we get to 7, or what's the right way? Because
You can address it now.
actually, this is one where I've asked, and I've yet to really have a convincing example of how this isn't 6 and 7 aren't duplicates. I don't think you can uniquely violate them, and I think even when I posed my question to Alex, the best example he gave was you could exceed the allowed what you have permitted for, but that would just mean that you didn't have a permit for what you removed. And I kind of keep going around in circles of how you can uniquely violate these two. I know that in the kind of towns presentation, they say that they're unique, but if somebody can't articulate examples of how they're unique, such as canopy coverage versus points, those are unique to me. Erosion control versus moving a quantity of earth, those are unique to me, but this all just seems to be the same activity and just kind of come out from two different directions. So this is kind of where I'm at. I'm happy to discuss that, but the duplication of this one I actually find most compelling.
Just to be clear, Greg, I'll read violation 7, removal of vegetation less than 3 feet in height without a permit. All existing vegetation less than 3 feet in height, including shrubs and general ground cover, has been removed within 100 feet of the normal high water line of Sebago Lake for much of the lot's shorefront without a permit from the code enforcement officer, referencing shoreline zoning provisions, section 14, table of land uses, item number 5, clearing or removal of vegetation for activities other than timber harvesting. I will say, Greg, that sort of this new round of questioning and clarification, I'm more in line now with you on this one. I don't see how they can be. I recognize that they are two separate items in the ordinance, and I do understand how, understanding of Alex saying that as they go through the ordinance and looking for violations, these are two separate sections that could be cited. But I would agree with you that how can you do one without the other? So ultimately, I do fall more. I'm seeing these more as duplicative, that you really can't have one without the other. So, but they are two separate items. So, kind of, I guess I feel like I'm on the fence now. But you've brought me closer to your side. Tom, Fred, or Pete.
I guess for consistency, what would be the difference? I'll ask Greg. If cutting down trees and cutting down trees without a permit, how is vegetation different than that?
Well, there's certainly, I'm not the code enforcement officer, so I'm not sure if my examples matter. When I asked Alex if there was, and I've asked him multiple times, if there was a good example, I feel like he would have readily put forth. I can give you my best interpretation of the question you've asked, which would be, I think you can cut down trees and you can do it and you can maintain the points that you're required to maintain, and you can maintain the canopy coverage that you're required to maintain, but you might have still had to have a permit to cut that tree down because of its location. And therefore, the only thing you'd be in violation of is cutting down a tree. Now, you could cut down a lot of trees, violate the point system, not have a permit for those trees, and remove the canopy. And those are all kind of unique aspects, unique violations of what you did, which goes to speak to the egregiousness of what act you did. In this particular case, I'm not sure that one's a modifier of the other. I feel like they're the same issue. That's kind of what I'm proposing.
It's a tough one. I mean, because you're looking at vegetation that's actually inside the riprap, which is right close to the water. So, I mean, it's obviously going to affect the runoff of possibly coming down over, you know, the riprap. Plus, as you go up by the stairways, you know, on the sides of that, you know, that has been removed too. And, you know, multiple areas. So, I mean, it was definitely removed, and I believe there's no proof of a permit anywhere.
So, yeah, Greg, I appreciate that you said the word qualifier there. I know under Alex's write-up, he's saying removal of vegetation less than 3 feet in height, and then removal of vegetation less than 3 feet in height without a permit. That's his write-up. The shoreline zoning provisions, though, for number 6, talks about clearing or removal of vegetation activities other than for timber harvesting. And then further section C talks about existing vegetation under 3 feet in height or other ground cover. Whereas the item reference for permitting is item number 5, clearing or removal of vegetation for activities other than timber harvesting. So there is no qualifier there in regards to 3 feet in height. So there is the difference. So in Alex's write-up, his items reference 3 feet in height on both. However, the zoning or the ordinance is one references specifically 3 feet in height, and the permitting one just references clearing of vegetation just in general. So there is the qualifier.
Sure, I think there's a qualifier, but I don't think you can uniquely violate one without the other. So like it's a redundant qualifier. Like I can add removing green vegetation would also be a qualifier perhaps. And like, that's not like, no one's you know, like that wouldn't make sense. And I think that like, we all know that the ordinances are fairly tricky, and we always try to interpret them the best we can. But like, I do feel like this is being a little opportunistic in saying, hey, I can get you from both directions on essentially the same act. So I don't know. I mean, I'm not going to belabor the point. I think of that just sharing. That's my thoughts on how I view these.
Anyone else?
I mean,
Go ahead, Fred.
I mean, I still feel that, you know, there's, again, you're removing less than 3 feet, and you actually looks like removing even more than 3 feet in height stuff without a permit. And I believe that, you know, the town was in writing issuing, you know, both violations. And just looking at the pictures shows all, you know, shows that. I mean, that's there to protect the land and to protect it, you know, from eroding.
Right. I don't think Greg and I are disagreeing that, you know, it's either one, both are valid. They just appear potentially duplicative.
Can we get to a motion handling duplicate, no, whatever, the duplication? Word something to that and at least resolve whether it's one or two violations.
Makes sense. Motion.
Anybody want to try articulating a motion for that?
You do such a good job. Who would go after the?
So how about a motion to grant the appeal in part and consolidate violations 7 and 8 into a single violation of failing to obtain a permit to cut vegetation less than 3 feet tall.
Are we on
I think it's violation 6 and 7, I think.
6 and 7?
Oh, I'm sorry. Yeah, I'm reading from the prior decision where this issue was raised. So yes, revise my motion to read 6 and 7.
Seconded.
Okay, so just to be clear, a yes vote on this would, I guess we can sort of phrase it as like effectively vacating 6 and 7 and then modifying the CEO's notice of violation to read one single violation. A yes vote here would be in favor of the appellant and would have the effect of consolidating this violation, and then we would take a separate vote as to whether this single violation occurred. Okay.
Those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, no.
Fred Miller, no.
Lockwood, yes.
Okay, so that carries 3-2. So essentially 6 and 7 are vacated and consolidated into a single violation. And I'll call that, I think it's fair for me to say that the violation here is we're considering both of the statutory sites. So the table of uses as well as 15 QC. Okay, I'm seeing head nods. So now let's take a vote as to whether this new consolidated violation should be upheld. So the question here would be whether there was in fact cutting without a permit.
Yeah. Do we need to? I believe that we already articulated our points on that. Should we
Yeah, I don't need you to articulate again.
Okay. All right.
And a motion here. So
Okay. I moved up uphold essentially the combined result of 6 and 7.
Okay.
So moved. Yeah, sorry, seconded. I'm sorry, all those in favor, David Murch, yes.
Greg Dean, yes.
Lockwood, yes.
Fred Miller, no.
I hate to ask, could you reword that or repeat the motion? I'm not sure we're talking the same subject anymore.
That's fair. That's fair.
I'm kind of the same way, but
if there's confusion, we should
Right.
clarify. Okay. I'm sorry. I told you I shouldn't have tried to make a motion. Let's let the lawyer that we've.
Yeah, I actually think you were clear, but let me repeat it. So the motion would be to deny the appeal as to this argument and uphold the combined violation 6 and 7. So
we're removing one of the violations that the town.
So that's already happened. So
Right.
these have been consolidated. So
Okay.
Now pretend we're looking at one motion that says the MCL violated 15 QC and 14 line 5.
Under one,
Right. So
under one violation.
right. So a yes vote is to deny.
I understand now. I understand.
I thought both you and I, Fred, were maybe on the same page, confused.
Right, yes.
So can we just take a revote? Is that how we do it?
Yeah, so why don't we just consider that other motion rescinded and let's have a so moved on what I had just articulated.
So moved.
So moved.
Okay. Second, yeah. Roll call.
David Murch, yes. Favor.
Tom Hennessy, yes.
Lockwood, yes.
Fred Miller, yes.
Okay.
Get a vote from Greg. Did you vote on that, Greg?
Oh, I'm sorry, I must have been on mute. I would say, yes, Greg Dean, yes. I apologize.
Okay, so next issue is violation 8. No, hold on.
That's correct. Well, this is the 9 and 8, yeah.
So unpermitted shoreland stabilization, no permit. Stabilization of the shorefront was completed from the land without a permit from the planning board or code enforcement office, referring to shoreland zoning provisions, section 15, land use standards, section C, piers, dock, wharves, bridges, and other structures and uses extending above or below the normal high water line of a water body or within a wetland. Further, section 12, vegetation may be removed in excess of the standards of the standards in section 15Q of this ordinance in order to conduct shoreland stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. When necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access way must be restored. Revegetation must occur in accordance with section 15T.
Sorry, are you reading, are we on, sorry, I've lost the thread here. Are we on violation 8 or 9?
Violation 8, but they read the same.
Okay.
So I just have before we comment on this, can I ask a clarifying question? Because I was actually confused during the testimonies, and I think there was a procedural question that was brought up around whether or not 8 was being considered for appeal. And
yeah,
I know that we entertained evidence as it pertained to 8, and I think it was more of an omnibus approach to viewing everything under 8, or at least 8 and 9 together. But I don't know if 8 has actually been appealed. So can somebody just clarify whether or not it has been appealed from just a legal perspective?
So I think you're right to raise that point. So the board previously on a 4-1 motion allowed questions pertaining to violation 8. But I think you're right to draw a distinction that the motion there was pertaining to whether or not that line of question and that evidence should be allowed. So I think the board needs to make a determination now as to whether the argument that violation 8 should be vacated was raised.
So the way you've worded that, just to clarify a little bit more, there's two things here. Is it in the appeal as it was written to the town? And then was there an argument made that it should be appealed in the line of questioning that was kind of made during this the session yesterday? So I think that they're different answers maybe, and I want to understand if it matters.
Yeah, I guess so. What I'm saying is, so yesterday it was about whether the line of questioning should be allowed. So I really viewed that as an evidentiary issue. And
okay.
I think I even advised you to allow that in. But that ruling that the board made, I don't think, in my opinion, it doesn't mean that the board concluded that the appellant in fact did raise violation 8. And so I think the board needs to make that determination. Should it consider the arguments pertaining to violation 8? So the town objected and said that, I think when made the arguments, I think I can fairly characterize here, was that it was not fairly raised. It was, there was an argument about duplication, but there was never an independent argument in the notice of violation pertaining to 8. So it would not be appropriate for the board to weigh in on violation 8. The appellant, on the other hand, argued, the standard here should be analogous to a pleading standard in litigation, and that is a very, very low burden. And so the town was on sufficient notice that violation 8 would be challenged and was effectively denied by management controls.
Well, I believe the appeal goes 6, 7, 9. I don't know if we can even address something that wasn't appealed, even though there was questioning surrounding it. It may come into consideration when we talk about perhaps duplication with violation 9. But unless I'm mistaken, I open to anybody else. I just kind of look at the appeal, and then I look at the town's kind of response, and I don't really see that it was really on the table for actually being appealed.
Yeah, and I would agree, Greg. And to clarify, this is specific to no permit. Unpermitted shoreland stabilization, specifically no permit. And I would agree. It wasn't in the written appeal to be addressed. So. It was helpful, as you said, in looking in combination of 8 and 9, but I don't see. There was no request to vacate 8 that I could see. So,
do we even need to entertain? Like, there's no motion to make.
No, I don't need a motion. I just need a sense of the board. You can even take a vote if you want, but it's not going to be an emotion or a finding that I'm not going to. Basically, if the majority of the board decides that's not an issue we have to address, it's just not going to appear in your written decision, we'll move on. So why don't you just give me a show of hands, who thinks that we should move on and not consider arguments related to violation 8.
Yeah.
So I'm seeing four hands.
I'll be okay with that.
Okay, so I see unanimous on that point. So I suggest that we go right to violation 9, right?
shoreline stabilization, no barge. Stabilization on the shorefront was completed from the land when it could have been completed from the barge, which the contractor Rob Durant owns. This is the exact same shoreline zoning provisions that I had previously indicated. Kind of specifically it. Let's see. Trying to find the barge part. So under section C12, it does say construction equipment must access the shoreline by barge when feasible as determined by the planning board. And it was indicated, during testimony that, barge work, Rob Durant did say that barge work was feasible, at least in terms of like a restoration project. Problem is it never made it to the planning board, which it was supposed to have. And the planning board's really the ones that determination. Fortunately, they weren't able to make that determination, so it was never brought to them. I'm fine just to keep this one in place and not vacate it. It never was brought to the planning board, so never an actual determination of feasibility wasn't even able to be determined. However, you do have someone subsequently saying, Rob Durant, who owns the barge, saying that it would be feasible, at least for the reconstruction project at the time of year which they were doing it. So I just throw that out there.
Yeah, I tend to agree.
Right. I agree.
I agree.
I agree.
Okay, how about a motion to deny the appeal in part on the basis that violation 9 should be vacated and uphold violation 9. So motion to uphold violation 9.
So
So moved.
Seconded.
all those in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Okay. So
Just to, okay, no, go ahead.
no, you go right ahead.
I do believe there was an argument made that we may have overlooked that we might want to address in the, even though we've skipped 8, there was an argument made that 9 was duplicate to 8. And I feel like that should at least be considered. So, you know, because it's possible that we could still consolidate 8 and 9 and not address 8 in its specific instance. So
I agree with you. That's what I was trying to pull up was the notice of appeal. I think you did summarize that accurately.
so should we?
I guess it'd be a motion to consolidate those violations.
So yeah, so moved. I'll make that motion. Or do we need to discuss first?
So we can second it and then discuss it and then vote on it. So I'll go ahead and second it. So one was for no permit, the other one was for not using the barge. If I look at our ordinances, stabilization, looking at 8, stabilization of shorefront was completed but from the land without a permit from the planning board or code enforcement. Does talk about section 15C12, vegetation may be removed in excess of the standards of section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. And then the second sentence to that same section is construction equipment must access the shoreline by barge when feasible as determined by the planning board. So 2 separate items for the planning board. One, the feasibility of a barge use. The second is providing a permit for the stabilization of an eroding shoreline. So I do see these as 2 separate items, both requiring separate actions from the planning board. So I don't see them as one and the same or can be combined.
And fair to say that the same reasoning the board used, you would agree with the same reasoning that the board used when it dismissed unanimously this argument when it was brought up as to Fernwood applies here?
Yeah.
Done. Any further discussion? I would call the vote.
Sorry. All those, I forget, what did we motion?
So this was actually a motion to, I guess, grant the appeal and consolidate these. So a yes vote would be in favor of the applicant, and no vote would be in favor of the town.
So I will say David Murch voting no.
Greg Dean, no.
Tom Hennessy, no.
Lockwood, no.
Fred Miller, no.
Okay.
Unpermitted tree removal within 100 feet of Sebago Lake. Multiple trees have been removed within 100 feet of the normal high water line of Sebago Lake, creating an illegal opening in excess of 250 square feet. While the ordinance does allow for normal hazard removal of hazard trees as defined, this is only allowed after inspection by the code enforcement officer as described in shoreline zoning provisions. Section 15R1, hazard trees in the shoreline zone may be removed without a permit after consultation with the CEO if the following requirements are met. Requirement A, within the shoreline buffer, if the removal of the hazard tree results in cleared opening in the tree canopy greater than 250 square feet, replacement with native tree species is required unless there is new tree growth already present. New tree growth must be near as practical to where the hazard was removed and must be at least 2 inches in diameter, measured at 4½ feet above the ground level. If new growth is not present, then replacement trees shall consist of native species and be at least 4 feet in height. Shall be no less than 2 inches in diameter. Stumps may not be removed. Provisions, section 15, land use standards, Q, clearing or removal of vegetation or activities other than timber harvesting. Number 2, except in areas to describe in paragraph 1 above within a strip of land extending 100 square feet. Horizontal distance inland from the normal high water line of a great pond or river flowing to a great pond or within a strip extending 100 feet. Horizontal distance from any other water body, tributary, stream, or upland edge of a wetland or a buffer strip of vegetation will be preserved as follows. There shall be no cleared opening greater than 250 feet in the forest canopy or existing woody vegetation if a forested canopy is not present, as measured from the outer limits of the tree or shrub crown. However, a footpath not to exceed 6 feet in width as measured between the tree trunks and or shrub stems is allowed for accessing the shoreline, provided that a cleared line of sight to the water through the buffer strip is not created. So
just to be clear here, we're talking about violations 10, 11, and 12.
number 10,
Yeah, that's 10.
Okay, so let me just say from how the appeal was framed and addressed, these were sort of treated collectively. So we could take them one by one if you'd like.
Yeah, I think so it's just my understanding of the appeal is that there's was definitely an argument made individually as it pertained to the individual ordinances, and then there was an argument made that they were duplicative. I'm not sure procedurally what we should do, but at least they seem to address different arguments made by the appellant, and then kind of one argument made that they're duplicates.
All right, so why don't we address the duplication argument first? So I'd suggest a motion to consolidate 10, 11, and 12.
So moved.
I'll go ahead second. So I know 10, 11, and 12 all are referencing separate sections of the land of the shoreline zoning provisions. Unpermitted tree removal with 100 feet of Sebago Lake. And then vegetation removal in excess of what is allowed by the point system. That's number 11. And number 12 is just removal of vegetation without a permit.
Just a clarification is the same, so 12 is the same ordinance as 7? That's being cited.
That's it. Yeah, that,
Yeah.
yeah,
I mean, I think 10 and 11 are pretty unique. I'm not convinced that 12 is a new violation.
So let me ask Attorney Wagner if.
Hey, David, we can't really hear you, or at least I can't.
Yeah, sorry, something's going on here. I have a question for, I guess, for Attorney Wagner. I mean, Greg and I, and perhaps the others picked up on the fact that 7 and 12 are referencing the same ordinance item, but it was not brought up in the actual appeal. So do we address that any further, or, I mean, can we come up with stuff on our own like this? I'm guessing, I don't know if we can or can't.
Yeah, you can do this on your own, though. Actually, I do think during arguments that Attorney Rachel made this point. And I'm seeing her nodding her head. Yeah, so I do think it's raised, and even if it wasn't, it's fair game.
That's why I brought it up as well. I have it in my notes as something that was brought up. So
Yeah. Well, just in general, I would think 12 should be. I don't know, do we say we roll 12 into, what was it, 6 and 7?
yeah, I mean that would be what I would propose. I mean we've already kind of consolidated 6 and 7. So whatever the
That would be.
I just don't see how you can do 6 or 7 and 12, and that doesn't.
That would be my thoughts as well.
So we could maybe Tom could withdraw his motion, and then someone make a motion to how about vacate 12 on the basis that it's duplicative of 7.
I'm in favor of doing that.
I'll need to officially say some words to say I remove or vacate or I withdraw my motion. You have to do that.
I withdraw my motion.
I will make a motion to vacate violation 12 as it is duplicative of item violation 7, which was rolled into 6 and 7.
Ask a question, Dave.
Yeah.
On 6 and 7, I believe I voted no on that, right?
The consolidation you did, yes. Yep. But then they were upheld. It was upheld.
Right. Right.
Yeah.
And so what now we're trying to add into there that the permit will be removed from this violation, and we'll just attach it to 6 and 7.
Well, what it would do is vacate notice violation 12. So it would grant the appeal in part and vacate notice of violation 12 based on the reasoning that this is duplicative of violation 6/7.
So we're not really, we're just basically taking 12 away and not really adding anything, because what you're saying, they've already been
Yeah, it functionally it's the same as, I know we've done it before as a consolidation motion, but functionally it's the same thing in my opinion. So I think here, by voting for this, you'd be voting for the appellant's position and vacating number 12.
Maybe that's based more on the trees.
This particular motion would be based on the idea that it's duplicative
With the vegetation too.
with number 7, right?
It's a reference spread to the exact same shoreline zoning provision item. And we address that exact same item under 6/7.
So the only difference I see between the two, though, is one is no permit for removal of vegetation and one is no permit for removal of trees. Those still considered the same?
Well, the shoreline, the table of land uses is clearing or removal of vegetation for activities other than timber harvesting. So clearly, if they include timber harvesting, then vegetation could include trees, or vegetation is, 3 feet or less.
In 6 and 7, there was none for no permit for trees, correct?
Well, 6 and 7 pertain to cutting a vegetation less than
Correct.
3.
And this one pertains to cutting a tree without a permit.
Pertains to vegetation generally, so that I think what you're getting at is that would include both vegetation and
The trees that were cut in that area.
or at least I'll let 12 speak for itself, which is vegetation has been removed.
So it's just saying that the vegetation was removed, but it was not for timber harvesting. So in other words, they didn't remove it because of tree removal.
Well, I think all we're saying, maybe to help clarify, is that I was proposing that 12 and 7 are identical, and 7 and 6 have already been combined. So it's almost by definition redundant to address 12 at this point. And that was that was what I was proposing, and that we just vacate 12 and address 10 and 11 as unique violations that need to be addressed.
I think what you can potentially get hung up on is the labeling that Alex used. I mean, 7 says removal of vegetation less than 3 feet in height without a permit. And then 12 says removal of vegetation without a permit, but they both refer back to the exact same shoreline zoning provision, which is clearing or removal of vegetation for activities other than timber harvesting. So when you refer back to that particular ordinance item, there is no qualifier of height there. This is simply removal of vegetation.
Mm-hmm. Which was different than what Alex has, right?
In terms of his labeling, 12 and 7 are labeled different, but they refer back to the exact same ordinance item, and that ordinance item has no height qualifier.
So just to be clear, if we vacate violation 12 because of whatever reasoning, it's saying that that it's the only one that deals with permits, right? So
I think 6, 10, and 11 all require permits.
yeah, but does 11 say permit, or does it say it they took more trees than they should have? I guess what I'm saying is 10, 11, and 12 say 3 different things,
Mm-hmm.
3 individual things. They're not. So at the moment, I'm not in favor of consolidating.
We were not. Are you thinking that we're consolidating 10, 11, and 12, Tom?
No, I think what Tom's saying is that if you were to take out 12, then none of the other violations would cover the removal of trees without a permit. Is that
Yeah,
what you're saying?
exactly what I'm saying.
Right.
Yes.
Exactly.
I agree.
So I don't know that we need to have a motion, or we just proceed with 10, 11, and 12.
Well, we do have a motion on the table to vacate 12 on the basis that it's duplicative of 7/6. So I think we do need to have a vote on that. And then I have clear direction depending on which way that vote goes as to what the findings are. So
Had that been
Okay.
seconded?
I'll second it.
I believe it has, yeah.
So I know David made the motion after Tom withdrew his, but I did not hear a second on that.
Well, Tom just seconded now, so
Yes, exactly. Thank
Yeah.
you.
Look, let's move to voting.
I appreciate you keeping a clear record. I rely on your minutes greatly. So yeah, unless there's any further discussion, why don't we have a vote on this?
So the motion was to vacate. So David Merchant in favor of vacating.
Greg Dean in favor.
Tom Hennessy, no.
Fred Miller, no.
Pete Lockwood, no.
Okay, so the motion fails. So I think what that brings us back to is let's start with 10. Oh, actually, sorry. Before we do that, I do have a direct message here from Attorney Wilson, and he's raising what I think is a very fair point, and I feel his pain having been in his shoes before. Which is so his message was, am I correct in suspecting our appeal won't be reached tonight? Well, rather than read his message, I'll just turn it over to Attorney Wilson. Do you want to just, I think he has some concerns about if his item will be reached or not tonight. And it's just his client's having to pay for his time. So if we can try to provide some idea of if we think we're getting to that item or not.
And no rush, honestly, and I didn't mean to, I didn't want to delay where the board was going in this case. It's just I noticed that I think there's the rest of this homeowners and then followed up by the appeal by the construction company. And I didn't know how large that secondary part was. And if there was any hint of reaching us tonight, I'm happy to stick around. I just, I didn't want to bill my client, obviously, if they're, for sitting around if I didn't have to, but I'm happy to wait if if the board does think we're going to get reached tonight.
Yeah, so our bylaws state that we don't take up any new items after 10 p.m. So if we are able to complete this particular topic, which we're currently on, we could potentially move on to our next item, but unfortunately you're the item after that. And I know that we will not be able to complete our next item before 10 p.m.
No, understood, and that's what I expected. I appreciate you taking me out of turn just to hear this. I would say this is our second here, and again, no rush. I think that our issue, as far as I'm concerned, and I don't know if you even glanced at it yet, and Alice can back this up, there's no dispute about what happened. I don't think that the recitation and argument would be overly long. I don't know if it makes, if it would help you all to maybe set it specially or hear it at the beginning of a meeting at one point to help move sort of the docket forward. Whatever works for you all, I'm happy to do. Just let me know the best way to sort of squeeze this in and maybe get something off your plate. But again, it doesn't have to be today, obviously. My clients are very patient.
Understood. I know Sandy helps us to formulate the agendas, so I will.
Greg, we're having a hard time hearing you.
Can you hear me?
No.
Hey, David, try this. Get close to your screen and talk. Now try. Oh, now it's not working.
I heard you. I think you had said that Sandy has a lot of input on how to set the agendas, and I'm gonna, like I said, my clients are really patient, and they're gonna go with whatever you guys think works. I only feel badly because I've been here a couple of times on their dime. And I also just want to make sure it's convenient for you. So whatever works, Sandy, you know, just email me however you want to fit me in best, and we'll make it work. But I appreciate you letting me go a little early this evening. And if for any reason you reach us, Sandy, I believe, has my cell phone, and feel free to reach out.
Will do. Thank you.
Thank you, everyone.
Good night.
So, violation 10.
Anybody hear me?
Yep.
Okay. So if I cut out terribly, Greg, I'm just going to ask Greg Dean, I'm going to ask you to sort of take over, and but then if it gets super bad, I'll work towards calling in. Okay. So anyways, item 10, which we have just read.
Yep.
Unpermitted tree removal within 100 feet of Sebago Lake.
We've lost you, Greg.
Yeah, so Greg, do you think you can take over on this one?
I mean, David.
Yeah, sure. He just read 10, right? So
Yeah, I don't think we need to reread it. Again, I suggest, for example, we could take a look at I know you've been following along with the proposed findings of fact and law, and we could use that as a guide for starting the discussion, or however you want to lead it.
yeah, so I mean, this is basically for the let's see, the excess of 250 square feet. I think, where are we procedurally? Just, is it, we want to have a discussion?
Yeah, let's have a discussion first. We get a sense of where the board's at, you know, or you could, you know, propose a motion and have a second and have discussion based off of that.
Sure. I mean, I'll propose a motion to uphold violation 10 on the basis that, well, I don't know if I need to include my basis in the motion. We can discuss it after, but I'd propose.
I'll second that.
Can you guys hear me now?
Yeah.
Okay. The dogs are all taken care of, so I'm not gonna worry about the dogs barking.
Man, what'd you do to them?
Well, my wife came home, she took care of them.
Wasn't worth it. Did you want to? You can take over.
No,
again.
why don't you continue this particular item, Greg?
So yeah, I think we had Fred second it, and so now we'll do a roll call vote.
Why don't you do discussion on this? Yeah.
Oh yeah, discussion. I mean, I'll start the discussion and then I'd like to hear feedback from fellow members. But yeah, I find the evidence pretty substantial in towards of that the threshold has been covered based off of the visual evidence. In terms of the issues raised around the potential inaccuracies, I think they fall well outside of a tolerance that would move it underneath the threshold of 250 square feet. One section alone was estimated to be 1,500 square feet. One tree was 320 square feet. I think it's pretty compelling evidence brought forth by the town. And my proposal would be to uphold 10 for those reasons.
I would agree.
You know, I agree with you too, Greg. I know there's been a lot of talk and discussion about, you know, how this was measured and whatnot. And, you know, how accurate that was. Again, I also remember that Alex said that, you know, the appeal wasn't written off and the violation wasn't written off in the day that he used his tool, but, you know, they had other measurements. But again, just from the visual of the pictures that we were looking at and what Alex did show us in that last presentation when he was being asked questions, it did show that, you know, that one tree was, you know, definitely over the 250 foot. violation. So I feel that they've met their burden to prove that it's over the 250 feet.
I would agree.
I agree.
Pete, anything to add?
I agree.
Okay, so we'll do a roll call vote. Greg Dean, yes.
David Murch, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, unanimous on that. Violation 10 is upheld. So I will leave it all to you to tackle the next one. I need to go run and find a charger for my laptop. If my video goes blank, I will be calling in.
Okay. David, you want to take over or you want me to keep reading 11?
Yeah, why don't you go ahead, Greg?
Sure. So the next item would be violation 11. This is for the removal of vegetation in excess of what is allowed by the point system. I'm not going to read the actual 15Q2B on page 45. I would like to make a motion to uphold violation 12. Does anybody want to second that?
Second that.
So we'll have a discussion. For reasons similar to 11, I found the visual evidence compelling. I did not find the issues brought up with measurement to indicate that there were areas that all areas satisfied the point system of the numerous areas that had trees removed from. So for that reasons, I would recommend upholding violation 12.
I just want to make sure you said
sorry,
for
11.
violation of 11, you meant violation 10, right?
No, I'm on 11 now. Sorry, I
Right,
misspoke
and when
and
you
said.
thought I said for the same reasons of violation 11, maybe I misunderstood.
Yeah, sorry. Yeah. For the same reasons with of 10, the visual evidence provided by the town, and I did not find the argument that the measuring methodology was inadequate enough to bring below the threshold of the requirement, the point requirement.
Correct. And I agree in the same way for the same reasons that I said for violation 10.
Tom, Pete, David?
I agree. Ready to vote.
Yep.
I agree.
Okay, so I think the next thing we'll do is a roll call vote. Greg Dean, yes.
David Murch, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
So that passes unanimously. So violation 11 is upheld. The next item would be violation 12. This is for violating the ordinance prohibiting the removal of vegetation without a permit. This is the shoreline zoning section 14, line 5 on page 13. I guess I'll make a motion to uphold 12 as well.
Seconded.
Discussion. I have a potential concern around my thinking that it's duplicative, but that's not really it's not really what we're voting on right now. So I mean, the facts seem to indicate that in isolation, this ordinance was violated. However, I do feel like it's duplicative, so I'm not sure.
So I think I can help you out here. I think you thinking that it's duplicative is a valid reason to vote to vacate it.
Okay. So then, for reasons I mentioned when we addressed 12, the consolidation of 12 with violation 7, I would recommend vacating 12. Anybody else? Thoughts?
Yeah, I'm 100% behind you on that one. I see this as no difference and recommend it be vacated as well.
So you and I would both be no votes on this motion.
Yeah, I'm gonna go back on what we talked about when we were having the discussion that, there are trees being removed here with no permit. And, it's, if we remove this, then they were able to remove trees that they were not authorized to remove. So I feel that, that they did work without a permit and that they should have filed for a permit for the trees and the vegetation.
Well, there would have been only one, but it would have been only one permit because it's, well, I mean,
No permit for the trees now. So if we vacate this, then there's no charge for them for the trees.
no, but
They remove trees.
but the ordinance says you get a permit for clearing or removal of vegetation for activities other than timber harvesting. So it doesn't matter if it's vegetation 3 feet or less or trees. It's the same overall category.
Just also to point out, Fred, I understand your comment. I just want to clarify that what we're not considering is whether or not there's the fines associated with this. So I think like whether or not 12 results in a no fine or a large fine, or is kind of not in consideration for whether.
Right, I'm not basing on the fine, I'm basing on the work that was done.
Okay.
I mean, it's like you build a house and you're not supposed to. I mean, it's not what you're gonna charge them for it, it's just that the work was done.
Okay. Yep.
Hey, Fred, I'm in full agreement with Fred. No permit for cutting down a lot of trees. And it already we showed that it violated the canopy and it violated the points count. So I'm right behind Fred.
And I agree. I see them as two separate things as well.
Okay.
Do the sort of majority here that believes the violation should be upheld. Can I ask you to weigh in on whether any of the evidence pertaining to the means of measuring the tree canopy and the accuracy of that, how you address that?
What, and when Alex was having questions answered to him, and when he brought up the grass, and he actually used that area, showing it that just that one tree alone, was more than that. Plus they took trees from the other side and going back towards the porch area of the house. I mean, that vegetation was all removed.
Okay, so you found Alex's testimony that
I felt that he had enough evidence and his measurements were credible enough for me to believe that his measurements were correct.
Pete and Tom, do you agree with that?
I fully agree with Fred. It's the measurements, no matter what accuracy you wanted to throw in at this thing, we're grossly over the limit.
Right, and I agree with that.
Okay, so I think we're ready for a roll call.
Okay. So roll call vote. Greg Dean, no.
David Murch, no.
Can you repeat the motion? Because I think we had two different motions, one to upheld and one to vacate.
So this is a motion to deny the appeal in part and uphold violation 12.
So we're going to keep the violation.
Right. So a yes
vote would keep it.
Yes vote is in favor of the town. No vote is in favor of the appellant.
I vote yes.
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 Okay, so that carries 3-2.
Yeah.
Okay.
So can I ask a question of Attorney Rachin? Did we miss any of your duplication arguments?
I don't believe you missed them. I just,
I know you don't like being
Yeah, no, you did not miss them. Thanks for asking. I appreciate it.
Does anybody on the board feel that there are any other arguments that need to be addressed? Okay, then I would entertain.
Actually, let me do clarify one thing. I did want to, just for the record, specify that if you'll recall, one of the arguments is that violation 8 would have subsumed all of many of those many of the alleged violations, like tree removal, earth filling, what else? Vegetation, tree removal, the removal of, or earth filling and moving of 10 cubic yards. So basically the argument was 8, had they gotten that permit under 8, that all of those other things would have been subsumed. So I want to make sure that that's also addressed.
Okay. So is that essentially, should the board vacate 8 on the basis that it's duplicative?
Actually, no, it's the converse. That should they basically strike all of those others that I had mentioned, because 8 would have subsumed those had they gotten their shoreline permit. That's what I was arguing, and that argument has certainly been made.
Right, but hasn't the board here? The board has determined that 8 was not challenged. So if
on the substance, yes, but certainly not on the dupe. And I think I heard many of the board members say that I think even Attorney Wyckoff agreed that yes, on the substance of the on the substance of whether or not violation 8 was appealed on the substance, that was not preserved. Of course, I don't agree with that, but that was the finding. But I think I heard folks, and maybe I may have misheard, but I thought that it was a very separate and distinct issue as to whether the duplication of 8 was also on the table. That was a very different thing. The substance of 8, whether or not that was substantively discussed or raised, but not the duplication. I think it's very clear if you look at the appeal itself that 8, its duplicative nature was raised.
So can I ask, and I'll let, the other attorneys weigh in, but how about Attorney Rich, could you suggest a motion for the board then to help frame the discussion on this?
Sure. Get my notes. If you would just, can you bear with me one sec?
Yep.
Okay. So as I had argued last night that, and I'm just going to frame it up and then I'll try to articulate a motion if I can. All right. So we talked about how had the applicant sought and received a stabilization permit, which was the violation under 8, it would have covered many of the other purportedly single violations violations 1 and 2, which were the earth moving and filling without a permit. Violation 4, which is the expansion of the shoreline. Violation 5, beach construction. Violation 6 and 7, which is removal of vegetation and removal of vegetation without permit. 9, use of the barge, and 10 through 12. So what I'm saying is that the motion would be to strike violations 1, 2, 4, 5, 6, 7, 9, 10, 11, and 12 because they were subsumed under violation number 8. I hope that, I know it's getting late. I hope that makes sense.
Nope, I follow that. So the motion is to strike 1, 2, 4, 5, 6, 7, 9, 10, and 11 on the basis, and 12 on the basis that those would be subsumed in violation 8. So I want to give Attorney Wyckoff a chance to weigh in on this, if he wants to.
Yeah, I do. I mean, I'll be very quick and concise. The only issue for appeal that was raised relating to violation 8 was that it was the same violation as as violation 9, period. That's it. That the other violations are subsumed within it wasn't raised in the application for an appeal.
Okay, so board, any, someone want to say a so moved, Attorney Rachen's motion?
Just a quick question, if before we make a motion, or we can make a motion and then vote, I guess. But I'm not sure. I mean, we did vote on whether 8 and 9 were duplicative. So if we were to make the motion as you've proposed, it's kind of. I'm not like. Do you still want us to do that? Like, given that we've.
I guess I want to put it up for a motion just so that I'm clear. You know, I think we
Got
should like this discussion here, but I get what you're getting at. Is that we've already effectively decided this issue. So when I make my decision, I can make that, you know, part clear, but let's just cue it up motion.
Okay, so I'll move as Attorney Rachen had suggested to vacate. I guess all 3 and 8 as they're subsumed by 8. I think it's a fair.
It's to motion to strike 1, 2, 4, 5, 6, 7, 9, 10, 11, and 12 as being duplicative of 8.
Okay, so moved.
Seconded.
Any further discussion? All right, roll call on that.
Greg Dean, no.
Tom Hennessy, no.
Fred Mellon, no.
Lockwood, no.
Okay. So I think that addresses everything. Seeing nobody disagreeing, so I would suggest, as we have before, that everything that we've taken is a sort of tentative vote, and that you make a motion to instruct me to prepare a written decision for the board to consider at its next regularly scheduled meeting.
So moved.
Seconded.
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mellon, yes.
Lockwood, yes.
Okay. Not gonna lie, I'm a little bit disappointed to see that it's 9:56 and not 10 o'clock, but I'll defer it to the chair as to whether we want to proceed to the next matter on the agenda.
Yeah, and I'll bring it to my board members as it's just as important for them. So our bylaws say we do not take up any new items of business after 10 p.m. for 5 minutes before that. So we do have the ability to take on a new item. I just need to know how you guys feel about that.
I'm strongly opposed to taking the next item up.
I am in full agreement with no.
I agree with that.
I'm okay with that.
Yeah, I would, given that this is our second night, I'm a little fried. I'd rather be able to give this next appeal better attention than what I believe I can.
Mr. Chair,
Yeah.
if I may just interject or argue
Of
against
course.
that.
Yep, no, go ahead.
All right. So I would just say, and potentially maybe the board would consider a cap of 10:45 or 11. I just hate the idea of having to come back and do this yet again. We're really close to resolving this or getting these done. These violations are identical, right? They are carbon copy. I participated in the presentation and consideration of the evidence on the last. Quite frankly, I think were the board to rule differently than it just did on substantially all of these, that would be more questionable, right? Than significant changes, right? Than to this. So I don't foresee making a lot of argument. I don't foresee spending a lot of time with it. There are a few points that I think I need to make, but primarily it's going to relate to who actually did the work as it relates to the tree removal on 10, 11, and 12. And so I don't know what Attorney Wyckoff's position, or if you're even just going to say, no, Braun, we're packing it in. But, you know, I just hate the idea of having to come back and doing this yet again.
Yeah, well, I think all parties need to have a voice in this. So Attorney Wyckoff, what is their thoughts?
I'm not in favor of starting it if we can't finish it. But I mean, I defer to the board. I mean, I heard you say that. I mean, it's your call. I heard you say you don't feel fresh and that it's your call.
Understood. I guess I'll put it out there one more time to the board members, given what we've heard. Again, what are your final thoughts on this?
I still think that we should start, because I really don't think even 45 minutes or an hour that we would get through this, you know, and do a good job of doing what we're here to do.
Yeah, I mean, we're at this point less than 120 seconds, but from a statutory requirement to vote to do it, I think we're just kind of. I mean, can I propose that we take a 2-minute bathroom break and then we can just vote on it? I think you're kind of threading a needle, to be honest.
I gotcha.
I don't. No one wants to come back and do it, but I feel like that's the best work we can do would be to come back and do it with a fresh, back rather than try to extend it from back-to-back nights.
Yeah, I kind of agree with that. I would, I hear what you're saying, Attorney Braun, but I want to give you and the people that you're representing our best, no matter what. So I'm not convinced we can give you our best tonight. So I will make a motion to table administrative appeal re-notice violation issue 310/2022 for applicant Gregory P. Braun on behalf of Big Lake Marine LLC. Robert Durant, member manager, location 28 Whitetail Lane. Do I have a second on that?
I'll second that.
All those in favor of tabling, David Murch, yes.
Fred Murray.
Tom Hennessy, yes.
Peter Lockwood, yes.
Okay, so we will look for next time.
I blame Jeff Wilson.
He did kind of get you.
Yeah, right. Disclosure, he's my former law partner. So I say that with, friendly thoughts. And I've already shared threats towards him via text. But are we going to do this just at the next regularly scheduled hearing date then?
That's what I'm looking at, unless I hear something different from the town or the fellow board members. Our next one's October 25th.
So the attorneys could conference again, and I can try to see if we can propose something. Of course, last time we did that, the best we got was this double header in September. So
yeah, I will say that I'm in as much as it matters. I know that there's a lot of schedules involved, but I would be in favor in trying to do it sooner, just to move the process along. But that's, for whatever that's worth, that's mine.
Yeah, and I have no issue. I agree with Greg. I wouldn't mind if we can attack,
Okay. While I have the board here, do you mind? Is there any dates in the next couple of weeks that don't work for the board members? I'll deal with the attorneys afterwards, because our schedules are obnoxious, as I'm sure all of yours are. But it's easier if I can get the board to weigh in now rather than chase you all down.
Yeah, October 25th is my 49th wedding anniversary.
Okay, we're crossing that off.
That's the normal meeting.
That's the regular meeting.
All right. You're clear either way.
I'm done, yeah. Extra roses that day.
Congratulations, by the way.
Thanks.
Yeah. I have
Greg,
I'm free whenever you guys need me.
For me, David Murch, Thursday evenings are any Thursday evening I am unavailable. But outside of that, I also have floating holiday on the 10th for Columbus Day, but outside of that,
I have various preferences, but nothing's a hard no. And so I would sort of defer to everybody's schedule, and if there's an option, I'll try to take a preference.
And the
I'm out
thing
of that.
that everyone needs to remember is what dates you can give me that may work. I still have to make sure that the broadcast is available.
Yep, understood.
I'm out of town until after October 11th.
Okay, so between now and October 11th is no good for you?
Correct.
Okay.
This is Tom Henderson. I may be unavailable for most of October, depending on what the hurricane does in Florida.
Okay, so do you think you could get back to me as soon as you have an idea if there's anything, if you have any
Yeah.
availability?
I'll should be able to give you an update within a few days.
Okay, thank you. Okay, so for now, it's tabled to the next regular meeting, but I will confer with the other attorneys and Sandy and Chairman Murch to see if we can come up with a special meeting in the interim, which would also save Mr. Wilson.
sounds good. Okay, so Greg Dean, thank you very much for filling in as needed, and I will make a motion to adjourn.
Seconded.
All those in favor, David Murch, yes.
Greg Dean, yes.
I'm gonna say yes.
Ed Miller, yes.
Be Lockwood, yes.
All right, thank you, everyone, and good night.
Good night.
Thank
Good
you for your
night.
time.
You're welcome.